Fresh matter, 2 weeks has happened, it has not been listed, my lord. It may be listed tomorrow.
All the co-office persons are on bail, my lord. Only have it tomorrow, my lord.
My lord, the 7A of PC Act, my lord. The petitioner is in justice since for like 15 days.
Fine.
And tomorrow.
My lord, list number 2.
One minute, sir, page wise.
Say number 4, my lord, I am for the petitioner. Kindly have 2 days time, limit. Say number 4,
Counsel for the 2023 matter, sir. No,
Friday, my lord.
no. I'll
Advocate
dismiss
on
this.
Ala.
Leisurely, you can file.
Ala.
Another
Advocate is on
petition.
proxy council, my lord.
Oh,
Proxy council.
Nothing.
Tomorrow, my lord. Tomorrow.
Let me see. Wait for some time. Next.
Please.
Serial number 16, my.
You have not furnished PF for issuance of notice. Counsel for the petitioner place for time to furnish PF with copies of the petition and annexures for issuance of notice to respondent number 2. If the same are furnished, issue notice. List of service of notice. Next.
Serial number 18, Your Honor. Kindly adjourn 1 week, Your Honor. Serial number 18.
Counsel for the petitioner place for time. Next.
Page 5, serial number 25 to 33. Page 6, serial number 34 to 36.
Yes.
Serial number 10. Kindly have 2 weeks.
You have to comply with the office objections. Please comply with it. Yes.
I make one mention, my lords.
Hmm.
In the second list, my lords, serial number 8. My lords,
Okay.
already, my lords, it has come up, my lords, for 3 times, my lords, before this honorable court. It has again come, my lords, in the first time orders list.
Compliance of.
Hello, office objections are completed. Interim bail is also granted. Your lordship directed the matter to be listed today. It has come in the second list, my lords, for first time orders.
Let me see. Then.
Since, my lords, state asked time to file objections, interim bail was.
I will consider. Let it come.
Please.
Let it.
Next one, serial number 1 for further argument, Master and Deshpande, Nagendra Nayak.
Lord, I appeal for.
Yes. Where is Mr. Deshpande? Where is he? Pass over.
2:30.
2:30, other 2 matters are there.
I will
Kalburgi
pass over.
matters
I'll
are
wait.
there.
I will.
Huh? EP there. Pass over. Let him come.
Last letter, PhD.
Responding.
Hmm? Hmm? Pass over.
Produce citation.
Pass over. Next.
Serial number 3, serial M.
ಇದು ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತು ರಿಸ್ಟೋರ್ಗೆ ಹಾಕೊಂಡಿದ್ದೀವಿ.
Restoration, okay. Can you not file fresh petition?
ಫೈಲ್ ಮಾಡಿದ್ವಿ ಅದು
Madi. No.
ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ.
When you can file a fresh petition, there will not be any restoration.
ರಿಸ್ಟೋರ್ಗೆ ಹಾಕೊಂಡಿದ್ವಿ ಅದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ.
No. It is already dismissed for default. You can file a fresh petition. Third line, counsel for the petitioner. On I-1 of 2024, no grounds are made out. The application is dismissed. Yes, next.
Serial number 4, Swami DC.
Petitioner.
Hmm.
Tomorrow, my lord. And
Why is that?
advocate is on registration, my lord.
Tomorrow illa.
Ala, our
Then
filing is-
Monday, my lord, on Monday.
Counsel for the petitioner place for time. Next.
Please.
ಅದು ಎಲ್ಲಿ ಇದು 2023 ಇದೆ. 1 ನಿಮಿಷ ಶೀಟ್ ಕೊಡಿ.
Successive bail.
Anyhow, you cannot avoid this code.
Sorry, my lord.
ಅದು ಫೈನಲಿ ಆಸ್ ಲಾಸ್ಟ್ ಚಾನ್ಸ್ ಅಂತ.
Please.
ನೆಕ್ಸ್ಟ್.
Serial number 5, Gopal Singh.
for petitioner.
Hmm. Yes,
Offenses are under section 466, 465, 468, 471 of IPC, my lord. Complaint dated 23/9/2023, 438 petition.
you are in criminal petition
My name is not reflected in the
in
FIR.
224, is it?
Please,
Petitioner is?
petitioner, in the FIR, my name is not reflected, madam. This is a, since there is apprehension, I have approached before this. Only accused number 1 name is mentioned.
And what about 281?
I'm for the petitioner, my lord. My lord, in this case,
They filed two cases, my lord. Petition number 1. And also the petitioner in the second matter, my lord, same, my lord.
No, in criminal petition.
372. They filed two petition, my lord.
May I submit, my lord? 284 is for accused number 1, my lord.
Where is 284?
5.1, serial number 5.1 is.
That is 281.
Please, my lord, 281 is for accused number 1, my lord.
Who is representing?
I'm representing in
Why he is
281, my,
finding it difficult.
my lord.
Accused number 1.
Yes, my lord.
What is your submission?
Please, my lord, they are the habitual and also they,
Adela on merits, you said there is
now
another petition.
they filed the two miscellaneous petition, my lord. Petition number 1 in the 224, my lord.
There is another petition.
They are 281. 5.1 is the another petition. Same, Ashok Kumar.
The different petitioners. Petitioners are different in both
one
the cases.
submission.
No, my lord. Ashok Kumar, my lord, petition number 1.
No, I will clarify, my lord.
My lord, that was withdrawn.
Earlier, what had happened, my lord, I filed petition for accused number 1 to 3, including the 281, serial number 5.1, ಅವ್ರಿಗೂ ಸಹ ನಾನೇ petition file ಮಾಡಿದ್ದೆ. Subsequently, this petition was tagged with this, tagged with my petition, and I withdraw the said petition for accused number 1,
Yes,
and same was amended, my lord,
yes.
as per the order of this honorable court.
Withdraw ಮಾಡಿದ್ದೀರಾ?
Yes, who will argue the matter?
My lord, I am representing for petitioners in 224, my lord,
Yes.
of 2023. Offenses are under section 466, 465, 468, 471 of IPC, my lord.
Yes,
Complaint dated 23/9/2023, my lord.
yes.
Complaint is at page number 11, my lord. The allegation in the complaint, my lord, on 14/9/2023, 7 customers. Allegation in the complaint, my lord, on 14/9/2023, 7 customers have approached the bank and tried to open a bank account with the fake documents, Aadhaar card and such a PAN card and such other documents. Subsequently, the same were not matched in their biometric application. Subsequently, they have asked everyone to come to the bank and give the biometric thumb impression and documents with respect to the same, my lord. And on 22/9/2023, 2 customers have visited, and when they cross-verified, these customers have not replied with regard to the original documents, and they started walking out from the bank, my lord, in page number 11, last para. And one person ran away from the bank, and the other person was caught, who is made as the accused number 1, my lord. He, according to the complaint, my lord, the accused number 1 has submitted a false documents, Aadhaar card and such other documents. Along with the accused number 1, some other customers also have submitted fake records and tried to open the bank account. This is the complaint against the accused number 1 and other persons, my lord. My grievances before this honorable court.
Who is that person who has came with a bandage?
Accused number 1 in the page number 12, as per the last para, my lord. Before the, when they caught the accused number 1, he said that he confessed that his name is Ashok Kumar, not Himanshu.
My lord, my submission here.
And in the same complaint, my lord, in the previous para, it is stated that along with that, one more person had come and he mentioned his name as Banavar,
In all, there were 8 persons.
7 persons. My lord. Only 3 of them have visited to the bank. In the para number 2, namely one Husiar has visited, and subsequently one Mr. Banavar has visited, along with the a person named as Himanshu, whose original name is Ashok Kumar.
Remaining 4,
Remaining 4 have not visited as per the complaint, madam.
Hmm.
Only they have submitted,
they contacted over phone.
they have contacted, tried to open the bank account, and the list is given in page number 12, madam.
You are one amongst them, 2 amongst them.
Two, my lord.
Yes,
My lord, the offenses as per the complaint, my lord, as per the allegation, my lord, complaint is registered on 23/9/2023. There is a 1-day delay of filing the complaint, my lord, first aspect.
Hmm.
And second aspect, my lord, 465, 466, 468, 471 is implicated, my lord. 466 will not attract to the petitioners, my lord, since there is no any such allegations in the complaint, my lord.
Hmm.
Except 468, my lord, 465 and 471 are bailable offense.
Hmm.
And apart from that, my lord, the only allegation against the other 2 persons, my lord, they have visited the bank and they ran away from the said spot. This is the allegation, my lord.
yes.
Except that there is no any allegation, and even the petitioners are ready to cooperate for any kind of investigation.
But the nature of the allegation requires you for interrogation.
My lord, only have humble
Not
submission.
a simple case of. any
No,
fraud.
these
No.
petitioners are not
Maybe you
submitted
will
any
come,
such
you will come
documents.
clean. You will come out very clean. But it is not a case for 438.
Will cooperate if
No,
court
sir.
imposes any stringent conditions.
My lord,
But accused number 1 was also not apprehended on that day.
no, my lord.
He was caught, sir.
My lord, the complaint given by the bank manager saying that there was some person named Himanshu, they have named him that his name could be Ashok Kumar, my lord. But here Ashok Kumar is a common name. Accused number 1 is arraigned in this case, but he is not a part of any of the complaint as said by the manager, my lord. And my lord, one more thing, the bank manager, while giving this complaint, has said that they have detained certain persons with the police. But my lord, no such arrest has even ever taken place till now, my lord. So where are those people who have been detained? So all these things make out that there was some banking wrong. And to overcome that banking wrong, this complaint has been filed. And certain people have been arraigned and they are being harassed for the same. And even in the complaint, my lord, the whole complaint is a typed one.
Yes.
The name Ashok Kumar is later on handwritten in the complaint.
Hmm.
So all this make out that it's a false complaint, my lord.
Yes. We cannot dub it as false because none of the accused are arrested yet. Yes, what do you say?
Please, my lord, they are making the account in different name, my lord, by producing the false document. And the police want to inquire into all the matter, my lord.
The common order. Petitioners. In the criminal petition 224 of 2024. Court just an apprehension of being arrested, even though they are not specifically named in the FIR. Next, the petitioner in criminal petition 281 of 2024 is arraigned as accused number 1 in the FIR and seeking grant of anticipatory bail. Next paragraph. The branch manager of HDFC Bank Limited, Airport Road, Bengaluru, logged the written information with the police on 23/9/2023, making serious allegations that the 3 persons have visited the branch with a request to open an account in their names and furnished the documents. 4 other persons have contacted over phone to open the account, stating that they are not available in the city. One of the person who came to the branch had a bandage in his left thumb. Bandage in his left and right hand. Right hand. The biometric impression was not matching and it has not validated. Thereafter, the persons requested to close the account and pay back the initial payments made by them. When those persons were asked about the other customers, to visit the branch, they never visited the branch. On the other hand, 3 persons who have visited have ran away from the spot. The information was provided to the police that all the 7 persons have tried to open the bank account with the false name and other details which were not matching with the documents which are submitted. It is suspected that they have submitted false names and fake documents. All the petitioners in both the petitions are before this court seeking grant of anticipatory bail under section 438 of CRPC. Looking to the nature and seriousness of the offense, I am of the opinion that these petitioners are required for interrogation. The contention of the learned counsel for the petitioners that there is delay in lodging the complaint and section 468 of IPC is not attracted, or that they are falsely implicated in the matter, have been accepted at this stage. Hence, the answer they point in the negative and proceed to pass the following. Dismissed.
Hearing to the petition, maybe passed over.
It is already dismissed.
Yes, sir. Filed an IA to
File fresh petition, sir. No recalling.
Passed over, madam. Maybe
No,
take
no
up.
passover, sir.
Yes.
I'll dismiss this application.
Maybe passed over,
Heard.
my lord, as a last opportunity. The senior is going to come up. He's held up in other.
Whoever may come, sir. When you can file a fresh petition, I will not recall the order.
He will come in.
Why I should recall?
Keep the apology. He will come and argue. The decision may be taken after that. Maybe
Pass over.
passed over. Great.
Counsel for the petitioner is absent, no representation. IA 1 of 2024 is filed for continuation of delay of 37 days in filing the application. And IA 2 of 2024 is filed for recalling the order dated 21/3/2024, where the criminal petition was came to be dismissed for default, that is for non-prosecution. When the petitioner or petitioners are not fully can file a fresh petition, I do not find any reason to entertain the application for recalling the order dismissing the petition. Therefore, there is no reason to condone the delay. Accordingly, both IA 1 and 2 of 2024 are dismissed. Then, Same order. Next.
petitioner, my lord. Within the bail application under 430 petition. Accused the petitioner aged about 27 years. And
He is accused number,
accused number 3, my lord,
accused number 3.
3.
In all, how many accused are there?
3 accused is there. Accused number 2 granted bail before this.
When he was arrested,
Arrested on 27/1/22.
what are the offense alleged? It is a successive petition.
Yes, sir.
Where is the earlier order?
Earlier order.
Have you not produced? What is-
Runner. FIR registered the accused number 1 and 2. Only see the FIR. Not mention this petition name in the FIR, my lord.
But on merits, it was dismissed.
And only statement of the accused number 1 implicated this petition, Your Honor. No witness, only circumstance evidence, Your Honor, my lord. Kindly see the complaint, my lord.
1 minute, 1 minute. Yes, on merits, it was dismissed. Oh,
Kindly
how
see.
you are entitled?
Only allegation against the accused number 1 and 2, Your Honor.
See, that is already considered. Your submission, similar submission was considered earlier.
Accused
On
num-
merits, it was found. Strong prima facie case is made out and you are not entitled for bail.
But the
But
complaint,
it's a change in circumstance.
same the circumstance, my lord, complaint allegation, clear the allegation accused number 1 and 2. After the accused number 1 arrested, after the accused number 1
Sir,
statement.
all these contentions were raised that were considered. The room in question where the deceased was found dead was booked in your name. Your ID card was found there. CCTV footage shows your movement. You came to the hotel, lodged the room and was inside the room. That was the
I
materials
am not,
produced.
not inside the room, Your Honor. Kindly see the complaint more.
Sir, all those things are already considered. I will not consider it once again.
Kindly see. Petitioner, accused number 1 and 2 is inside the room, Your Honor. In the
And
statement of.
where were you?
Room number 1. This petitioner in the room number 3, my lord.
Yes.
But
ಅದು ಅಲ್ಲಿ ಡಿಫೆನ್ಸ್ ಅಲ್ಲಿ ತಗೊಳ್ಳಿ ಇಲ್ಲಿ ಅಂತದ್ದೇನು ಹೇಳಿಲ್ಲ. Already all those things are considered.
But accused number 2 already granted the bail with this honorable high court.
So whether witnesses are examined,
No exam.
then see, while dismissing the petition, you sought for liberty to file fresh petition after examination of material witnesses.
But
And HCGP says CW1, 3, 7 to 14 are material witnesses. You can maintain a petition only after examination of those witnesses, not earlier.
after the petition, accused number 2 granted.
No, sir, sorry. Togolli. Petitioner, accused number 3 is before this court seeking grant of bail. It is noticed that the petitioner had filed a criminal petition number 11352 of 2022 on similar grounds seeking grant of bail. The said petition was came to be dismissed with a dismissed on merits with a order dated 14th February 2023.
On submission, my lord.
Petition was dismissed.
My lord, on submission, this petition not seized any weapons, this petitioner. ಯಾವುದೇ ವೆಪನ್ ಕೂಡ ಸೀಜ್ ಮಾಡಿ.
Stained clothes were recovered at your instance. All those things are already considered by this. court. Okay. At the time of dismissal of the petition, when a counsel for the petitioner has sought for liberty to file some application before the trial court after examination of material witnesses. When a HCP submitted that she refused 1, 3, 7 to 14 are the material witnesses. Therefore, liberty was reserved with the petitioner. When the trial court after examination of the aforesaid material witnesses, if he is advised to do so. Next. Admittedly, none of the material witnesses are examined before the trial. When a counsel for the petitioner again contends that there are no prima facie materials against the petitioner and he is falsely implicated in the matter. Then similar contentions are already considered and his bail application is rejected by forming an opinion that there are prima facie material against which suggest his involvement by giving elaborate reasons. I do not find any reason to once again reconsider the same. Hence, petition dismissed.
Nothing for the petitioner, my lord. My lord, on the same day, my lord, other court, I'm busy, my lord, I will produce the cause list also, my lord.
Whatever may be, can you not file a fresh petition? Is there any bar?
Oh, my.
Then file it. Third
My
line,
lord, may
say,
request
you-
you the
24 is
certified
dismissed.
copies, my lord. Written with the
Copy of
certified
the
copies, my
documents produced by the petitioner is ordered to be returned by substituting with the copies. Next.
Much obliged, my lord.
Counsel for the petitioner. Counsel for the petitioner is absent, same. I-1 of 1 and 2 of 2024 model ಮಾಡಿದ್ರು. Yes.
But I had filed an application for dismissal with recall and I have filed a withdrawal not to proceed the action. So
I will dismiss that.
please,
Same, similar. I-1 and
reserve with liberty.
dismissed. Dismissed, yes.
For the petition.
Hmm.
438. Offense is that 376 2N.
376 2N.
And section 4, 5 and 6 of Foursquare and section 9 of the Child Marriage Act. Complaint by the CDPO, my lord, kindly see the
This is
page number
438,
438, my
sole accused.
sole accused.
Ah.
Kindly see the page number 13,
Who
my
is
lord,
the complainant?
complainant, my lord. It
Who is the
C-
complainant?
CDPO, my lord.
CDPO. Age of the victim,
At the time of complaint, my lord, 17 years,
Ashte, 17 years.
more than 17 years. Page number 13, my lord. I'll read the complaint, my lord.
Hmm.
At the time of complaint, my lord, 18 years, my lord. Page number 13. ಮೇಲ್ಕಂಡ ವಿಷಯ ಉಲ್ಲೇಖ ಸಂಬಂಧಿಸಿ ಅಪ್ರಾಪ್ತ ಬಾಲಕಿ ರಕ್ಷಿತಾ ಮಂಜುನಾಥ ಕಲಾಟೆ ಗ್ರಾಮ ಇವರು 23ರಂದು ಜಿಲ್ಲಾಸ್ಪತ್ರೆಗೆ ಇವರು ಹೆಣ್ಣು ಮಗು ಹೆರಿಗೆಯಾಗಿರುವ ಕುರಿತು ತನ್ನ ಠಾಣೆಯಿಂದ ಅಪ್ರಾಪ್ತ ಸಂಬಂಧಿತ ವರದಿ ನೀಡುವಂತೆ ಕುರಿತು ಸದರಿ ಬಾಲ್ಯ ವಿವಾಹಕ್ಕೆ ಪ್ರಕರಣ ಸಂಬಂಧಿಸಿದಂತೆ ವಲಯ ಮೇಲ್ವಿಚಾರಧಿಕಾರಿಯಿಂದ 39ರಂದು ಪ್ರಕರಣ ಸಂಬಂಧ ಬಾಲಕಿ ಮನೆ ಭೇಟಿ ನೀಡಿ ಬೀಗ ಹಾಕಲಾಗಿತ್ತು ಎಂಬ ಮಾಹಿತಿಯನ್ನು ಈಗ ತಿಳಿಸಿ ಪುನಃ ದಿನಾಂಕ 27/11/2000 ಅಪ್ರಾಪ್ತ ಬಾಲಕಿ ಮನೆ ಭೇಟಿ ನೀಡಿ ರಕ್ಷಿತಾ ಮಂಜುನಾಥ ಬಾಲಕಿ ತಾಯಿ ದಾಕ್ಷಿಣ್ಯ ಬಾಲ್ಯ ವಿವಾಹ ಮಾಡಿರುವುದ ಇಲಾಖೆಯ ಸಿಡಿಪಿಒ ವಲಯ ಮೇಲ್ವಿಚಾರ ಸಮ್ಮುಖದಲ್ಲಿ ಹೇಳಿಕೆ ನೀಡಿರುತ್ತಾರೆ. ಸದರಿ ಅಪ್ರಾಪ್ತ ಬಾಲಕಿಯ ಸಾಲ ದಾಖಲೆಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದ್ದು ಬಾಲಕಿ ದಿನಾಂಕ 17/7 2005 ಜನನವಾಗಿದ್ದು ಹಾಗೂ ದಿನಾಂಕ 11/12 11/12/2000 ಮದುವೆ ಆಗಿದ್ದು ಜನ್ಮ ದಿನಾಂಕಕ್ಕೂ ಮದುವೆ ದಿನಾಂಕ ಹೋಲಿಕೆ ಮಾಡಿ ನೋಡಿದಾಗ ಬಾಲಕಿ 17 ವರ್ಷ 4 ತಿಂಗಳಿಗೆ ಬಾಲ್ಯ ವಿವಾಹ ಕಂಡು ಬರ್ತದೆ. ಆದ್ದರಿಂದ ಗಂಡ ಮಂಜುನಾಥ ಬಿನ್ ಕಲಾಟಿ ಅವರಿಗೆ ಬಾಲ್ಯ ವಿವಾಹ ನಿಷೇಧ ಕಾಯ್ದೆಯಡಿ ದೂರನ್ನು ಸಲ್ಲಿಸಬೇಕು ಕೋರಲಾಗಿದೆ. Based on that, my lord, investigation charge sheet also filed, my lord. During the investigation, my lord, our statement was recorded, victim statement was recorded in page number 28, my lord.
Statement of
Victim, my lord. Page number 28, my lord. At the time of
51 statement or 164?
161. Because 164 statement, my lord, they are not furnished, my lord, though we filed a copy application, my lord, they are not furnished. My lord.
Yes.
Case number 28, my lord. The filing, at the time of statement, recording the statement, my lord, her age is, my lord, 18 years, 5 months, my lord. I read the second paragraph, my lord. ನಾನು 23 ರಕ್ಷಿತಮ್ಮ ಇವರಿಗೆ ಜಿಲ್ಲಾಸ್ಪತ್ರೆ ಹೆಣ್ಣು ಮಗು ಜನನವಾಗಿದೆ ಅಂತ ಜಿಲ್ಲಾಸ್ಪತ್ರೆ ಮೆಮ ಬಂದಿದ್ದು. ಈ ಬಗ್ಗೆ 27 ಕಲ್ಲಾಟಿ ಗ್ರಾಮದಲ್ಲಿ ನೊಂದ ಬಾಲಕಿಯ ಮನೆಗೆ ಸಿಡಿಪಿಒ ಎಡಿಸಿ ಮೇಲೇಜ್ ಭೇಟಿ ನೀಡಿ ಆಪ್ತ ಸನ್ಮತಿ ಮಾಡಿದಾಗ ಬಾಲ್ಯ ವಿವಾಹ ಆಗಿರುವುದನ್ನು ಕಂಡು ಬಂದಿದ್ದು. ನಂತರ ವರದಿಯೊಂದಿಗೆ ದಿನಾಂಕ 26 ಠಾಣೆಗೆ ಸಿಡಿಪಿಒ ಕಚೇರಿಯವರು ದೂರು ದಾಖಲಿಸಿದಂತ ವಿಚಾರವನ್ನು PSR ಮೇಡಮ್ ನಾನು ಈ ದಿನ ತಿಳಿಸಿದ್ದು. ನಾನು ನನ್ನ ತಂದೆ ತಾಯಿ ದಾಕ್ಷಿಣಿಯವರು ಇಬ್ಬರು ತಿಳಿದುಕೊಂಡಿರ್ತೇವೆ. ನನ್ನ ಗಂಡನ ತಾಯಿ ಗೌರಮ್ಮನವರಿಗೆ ತುಂಬಾ ವಯಸ್ಸಾಗಿದ್ದು ಅವರಿಗೆ ಪಾರ್ಶ್ವವಾಯು ಹೊಡೆದಿದ್ದು ಅವರಿಗೆ ಬಸವೇಶ್ವರ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಚಿಕಿತ್ಸೆ ಕೊಡಿಸ್ತಿದ್ದು. ವೈದ್ಯರು ಅವರು ಬದುಕುವುದು ಕಷ್ಟವಾಗಿರುತ್ತದೆ, ಅವರನ್ನು ಮನೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಅಂತ ತಿಳಿಸಿದ್ದು. ಮನೆಗೆ ನಮ್ಮ ಅಜ್ಜಿಯನ್ನು ಕರೆದುಕೊಂಡು ಬಂದಿರ್ತಾರೆ. ನಾನು ಮತ್ತು ನನ್ನ ಸೋದರನಾದ ನನ್ನ ಗ್ರಾಮದ ಮಂಜುನಾಥ petitioner madam.
ಮದುವೆ admitted. Giving birth to a child is admitted.
Admitted, madam.
Date of birth is admitted. She was a minor, that is also admitted. There the offence is complete.
Completed, my lord. But in this case, my lord, they are the relative, they love each other, my lord. Subsequently, my lord, some dispute is there, my lord, because
Yes,
then
what
now
you
also,
say?
my lord, they are residing together.
Girl child is born, my lord.
Hmm?
Girl child is born.
Yes.
But at the time of the marriage, my lord, 17 years, 5 months, my lord. Not at in the
I think already charge sheet is already filed.
charged file.
So good. Motion for the petitioner is the sole accused, seeking dispute review on the apprehension of being arrested. The CDPO has filed the first information against the petitioner for the alleged offences. The date of birth of the victim is stated to be 17/7/2005. And she was married by the petitioner on 11/12/2022. Therefore, apparently, the victim was a minor at the time of her marriage by the petitioner. Even the statement of the victim recorded by the investigating officer under section 161 of CRPC discloses that she was married to the petitioner when she was a minor. She was given birth to a baby girl 23/9/2023. Therefore, there are strong prima facie evidence against the petitioner for having committed the offence. But now the investigation is completed and the charge sheet is already filed. It is not the contention of the prosecution, but the petitioner is required for interrogation. In the such circumstances, I do not find any reason to reject the claim made. Petition allowed subject to condition.
For the petitioners for accused number 2 and 3, my lord. Hence, my lord, is 306, my lord. So the complaint is page number, my lord.
In all, how many accused? In all, how many accused?
There are 6 accused, my lord. Accused number 1 is the husband. 2 and 3 are the mother-in-law and father-in-law.
Accused number 1,
Is the husband, my lord. Now I am representing, my lord, the petitioners.
how you are related to accused number 1,
They are the parents of the accused number 1. This
2
petitioner.
and 3,
Yes, my lord.
parents,
Parents.
4, 5 and 6.
4 or 5 are the brother of accused number 1. 6 is a far relative of the accused number 1. Atte,
How she died?
he committed suicide, my lord,
How?
by taking a pesticide, my lord, according to the complaint version, my lord. May I read, my lord?
Who is the complainant?
My lord,
Who is the complainant?
complaint is the mother of the complainant. This is, my lord.
Date of marriage?
Date of marriage, my lord, 12 years before, my lord, incident. 100 days is there. Exact date has not been mentioned, but before 12 years, no, 12 years before. Complaint is page number 22, man. Type it, sir. May I read, man? page number 22, annexure B, my lord.
Come to 23.
Sorry, my lord.
Come to page number 23.
I can. May I read, my lord?
Wait for some.
From ಈಗಿರುವಾಗ 22
Yes, proceed, sir, proceed.
ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿರುವ
Head 23 ನಲ್ಲಿ ಬನ್ನಿ to the relevant portion.
ಎಸ್ ಹೀಗಿರುವಾಗ ನನ್ನ ಮಗಳಿಗೆ ಪ್ರತಿನಿತ್ಯ ಮಾನಸಿಕ ಹಾಗೂ ದೈಹಿಕ ತೊಂದರೆ ನೀಡುತ್ತಿದ್ದ ಕಾರಣ ನನ್ನ ಮಗಳಿಗೆ ಮೈಸೂರು ಕುಟುಂಬ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ವಿಚ್ಛೇದನ ಕೋರಿ ಪ್ರಕರಣ ದಾಖಲು ಆಗಿ ವಿಚಾರಣೆ ಹಂತದಲ್ಲಿ ಇರುತ್ತದೆ. ಈ ದಿನ 25/1/2024
Filed this divorce petition.
Yes, the husband has filed, the accused number 1 has filed
Yes.
divorce. ಇರುತ್ತೆ. ಈ ದಿನ 25/1/2024 ಬೆಳಗ್ಗೆ ಸುಮಾರು 11 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಮೂರನೇ ಮಗಳಾದ ರೇಖಾ ಎಂಬುವಳು ಫೋನ್ ಮಾಡಿ ವಿಜಯಲಕ್ಷ್ಮಿಯು ಫೋನ್ ಮಾಡಿ ನನಗೆ ನನಗೆ ಹುಷಾರಿಲ್ಲ, ತಕ್ಷಣ ಬಂದು ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಎಂದು ತಿಳಿಸಿದಳು. ಆಗ ತಕ್ಷಣ ನನ್ನ ಮಗಳು ರೇಖಾ ಮತ್ತು ಅಳಿಯ ಜಯರಾಮ್ ಎಂಬುವರು ಗ್ರಾಮಕ್ಕೆ ಹೋಗಿ ನೋಡಿ ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿರುತ್ತೇವೆ ಎಂದು ತಿಳಿಸಿದರು. ನಾನು ಮೈಸೂರಿನ KR ಆಸ್ಪತ್ರೆ ಬರುವಷ್ಟರಲ್ಲಿ ನನ್ನ ಮಗಳು ವಿಜಯಲಕ್ಷ್ಮಿ KR ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಬಂದಿದ್ದು, ನನ್ನ ಮಗಳನ್ನು ವೈದ್ಯರು ಪರೀಕ್ಷಿಸಿ ನೋಡಿದಾಗ ಮೃತಪಟ್ಟಿರುವುದು ತಿಳಿಸಿರ್ತಾರೆ. ನಂತರ ರೇಖಾಳನ್ನು ವಿಚಾರಿಸಿದಾಗ ನಾನು ಮತ್ತು ನನ್ನ ಗಂಡ ಜಯರಾಮ್ ಇಬ್ಬರು 11:30 ಸಮಯದಲ್ಲಿ ಹೊಸಕೋಟೆ ಗ್ರಾಮ ಗಂಡನ ಮನೆಗೆ ಬಂದು ನೋಡಿ ಕೊಠಡಿಯಲ್ಲಿ ನೋಡಲಾಗಿ ವಿಜಯಲಕ್ಷ್ಮಿ ಸುಸ್ತಾಗಿ ಬಿದ್ದಿದ್ದು ಕೇಳಿದ್ದಕ್ಕೆ ನಿನ್ನೆ 24/1/2024 ರಾತ್ರಿ 8:30 ಸಮಯದಲ್ಲಿ ನನ್ನ ಗಂಡನಾದ ಹರೀಶ ಮಾದೇವಮೂರ್ತಿ, ಅತ್ತೆ ಮಲ್ಲಿಗಮ್ಮ, ಮೈದರಾದ ಮಹೇಂದ್ರ ರಾಘವೇಂದ್ರ ಎಂಬುವರು ಹಾಗೂ ಮಹಾದೇವಿ ಮೂರ್ತಿಯ ತಂಗಿಯಾದ ಶಿವಮ್ಮ ಎಂಬುವರು ಸೇರಿಕೊಂಡು ವಿನಾಕಾರಣ ಸಂಸಾರದ ವಿಚಾರ.
Yes, yes, next.
My lord.
What is the stage?
Stage is, my lord, FIR is filed, my lord. Investigation is.
Put accused number 1.
Accused number I'm not aware, my lord.
Don't know. Yes.
No, it's still under investigation, my lord. The serious allegation has been made. Deceased herself given a statement stating that, my lord, they are mentally, my lord, these accused persons are mentally or physically harassing the, my lord, deceased, my lord. Therefore, my lord, she has taken, my lord, extreme step to consuming the, my lord,
But they are
the
the
pesticide.
parents, not the husband.
Please, my lord.
They are not the husband, they are the parents.
Yes, my lord. Even against them also, my lord, she has stated, my lord. The deceased is also stated, my lord. They are also, my lord, harassing and, my lord, the giving, my lord, the
My lord,
physical,
there
my lord, and mental ill treatment, my lord.
Yes.
Therefore, my
What
lord,
is
it's
A1?
anticipatory. My lord, A1 is concerned. A1 also, my lord, he is absconding, my lord.
No, it is, the complaint is admitted, my lord. 6-7 ವರ್ಷ ಅವರೇ ಚೆನ್ನಾಗಿ ಸಂಸಾರ ಮಾಡ್ಕೊಂಡು ಚೆನ್ನಾಗಿದ್ರು. ದೇ ಆರ್ ವೆಲ್, my lord. ಅದು ನಿಜವಾಗಿಯೂ ಆಗಿದ್ರೆ ಅವರು ರಾತ್ರಿ ಆಗಿರೋದನ್ನ ರಾತ್ರಿನೇ ಅವ್ರ ಪೇರೆಂಟ್ಸ್ ಹೇಳ್ಬೋದು, my lord. ಅದ್ರಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಕೇಳಿಲ್ಲ ಅವ್ರ ಮಗಳು.
According to you, how she died?
May be committed suicide by taking pesticide.
Why?
My lord, there is a family dispute between the accused number 1 and 2, 1 and deceased, my lord.
But you are also in that house.
My lord, but we are now 12 ವರ್ಷದಿಂದ ಚೆನ್ನಾಗಿ ನೋಡ್ಕೊಂಡು ಬಂದಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಮತ್ತೆ ಇವ್ರಿಗೆ 66-63 ವರ್ಷ ಸ್ವಾಮಿ. 60 ವರ್ಷ ಒಬ್ಬರಿಗೆ, 58 ವರ್ಷ. And
petitioners who are arraigned as accused under 2 and 3 are before this court seeking grant of anticipatory bail with the apprehension of being arrested. The mother of the deceased lodged the first information stating that marriage of the deceased with accused number 1 had taken place about 12 years back, and they had gotten 2 children. For about 7 years they have led married life. And thereafter, there was dispute between the husband and wife. They stated that accused number 1 had filed a petition seeking divorce. And on the date of incident, it is stated that there was a quarrel between the deceased and the petitioner. And other accused have also abused her, as a result of which she consumed the pesticide. After hearing the incident, The sister of the deceased went to the house of the accused and shifted her to the hospital. But by that time, she had already breathed her last. Even though serious allegations are made against accused number 1 for having ill-treated the deceased and also instigated her death, these petitioners are their in-laws, and omnibus allegations are made for having abused her on the date of incident. Therefore, I am of the opinion that these petitioners are not required for interrogation, and they may be granted anticipatory bail, subject to conditions which will take care of solution. Accordingly, I answer the point in the affirmative in question of first. Allowed subject to conditions.
The petitioners are accused number 2 and 4. Brought the petitioner is in custody from 3 years, from last 3 years, 9 months. I have
When
produced
they
the
were
order.
arrested,
The petitioner was arrested on 21/8/2020.
20, both.
Both
Where is the earlier order?
have filed a separate compilation on 8/4/2021. Earlier order wherein Lord accused number 3 and 4 are approached this honorable court. And that petition was dismissed. Subsequently, A3 was enlarged on bail by the Lordship on delay in trial. Lord, in spite of taking coercive steps on the complainant, who is the police officer, he is not never appearing for the court. Court has issued a body warrant and imposed a fine of ₹3,000. And in spite of that, he has never appeared. And the punch witnesses is CW2 has turned hostage. And CW3, another puncher has been to abroad. And now the only 2 witnesses have been examined. The order sheet I have produced on last date, wherein Lord, the proceedings are clearly indicates that even police officers also not cooperating the trial.
Yes.
Please, my lord, the matter is posted for 12/6/24, my lord.
How many witnesses?
Variable warrant is issued, my lord.
According to him, only 2 witnesses are examined.
Please.
Is it a fact?
Only
But my lord, the offense, if they release, my lord, they do the same thing. Because, and still accused number 1 is
Accused
still
number 3 is already.
absconding, my lord.
Huh?
Accused number 1 is still absconding, my lord.
Him abscond. Abscond. Accused number 3 was enlarged on bail on similar ground. Parity.
But the witnesses are issued the bailable warrant.
Secure their prisons.
bailable warrant to the police who is the complainant.
Yes.
He is not appearing.
These petitioners, being accused number 2 and 4, are seeking grant of bail. Petition number 2 being accused number 4, along with accused number 3, had up this court with a similar prayer, filing criminal petition number
8/4/21 compilation.
earlier petition, which is that accused number 4.
Accused number 4 is not criminal petition 3320/21.
Filing criminal petition number 3320 of 2021. The said petition was scheduled to be dismissed. Today order dated 28/9/2021 on merits. by holding that in view of the seriousness of the offense, the petitioners are not entitled for grant of relief. Later, accused number 3 approached this court by filing criminal petition number 12441 of 2023 on the ground that there is inordinate delay in trial. The said petition was deemed to be allowed today order dated 25/1/2024, where it is noted that even though the charge was framed on 29/11/2022 and accused number 1 to 3 are in judicial custody, even CW1, who is the police officer, and the informant is not appearing before the court. PW was issued against him. Till date, his presence could not be secured before the trial court, and it is stated that only 2 witnesses could be examined by the prosecution. It is stated that CW3, who is the independent witness to the Mahazar, has gone abroad, and the other Mahazar witness, who examined as PW1, has not supported the case of the prosecution. Under these circumstances, there are no justification for the prosecution. There is no reason to detain the petitioners in custody. They are entitled for the benefit of parity with accused number 3. Hence, I am of the opinion that the petitioners are entitled for grant.
Judgment of the apex court. To be Prakash versus State of Orissa.
Huh?
One of the judgment of the apex court.
Allowed certain conditions.
That's kindly pass over, my lord. Additional SPP will be. Pass over, my lord.
In this
Okay.
matter.
Additional SPP will be appearing.
ಬಂದಿದ್ರಲ್ಲ ಇಲ್ಲಿ.
ಈಗ ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ರೀಚ್ ಆಯ್ತು.
Vartarante.
ಪಕ್ಕಕ್ಕೆ.
My lord, in the meantime, may I make 2 submissions, my lord, in this matter.
Hmm.
What has happened is, my lord, challenging this FIR, my lord, a 482 petition was filed earlier. And it came up before the vacation bench, my lord, coordinate bench of this honorable court. Lord, this honorable court, my lord, after hearing both the sides, my lord, even learned special PP was also there. A consensual order was passed, my lord, saying that, my lord, we shall not press this bail petition. And my lord, we shall go and surrender before the police and give statement. It is having regard to the peculiar facts of the case that, my lord, the petitioner is a device SP rank officer. And when his bail petition was pending, my lord, and he was pursuing that, this false case has been registered. That is, my lord, now it is a rift between inside the department, basically. And my lord, the 307 has been registered, my lord, saying car anna dash madidru forcibly, my lord, when they tried to arrest him, he escaped dashing the car anta anno tara ಒಂದು false complaint delay ಇದೆ. That is other aspect. But your lordship may kindly see the order. I may be permitted to place it on record. The consent order, my lord, and that was challenged before the Supreme Court, my lord. Here they, my lord, they say, all right, we want him for interrogation. Then, my lord, they take a U-turn. They challenge it by way of SLP. Lord, page 175, my lord, is the order passed by this honorable court. My lord, this honorable court, my lord, fairly, my lord, passed an order saying, no, FIR we will not pass. You can participate in the investigation and you can cooperate with the investigation. After all, he is your own officer. Why are you behind him? Like that, my lord, observations are made. And at the end, my lord, both the petitions, 2 crime numbers were there. Both the petitions were dismissed. Liberty was given to, my lord, to go and appear. We appeared also now, executed the bond also. But the last 176 page, my lord, there is undertaking given by myself, my lord, during the course of hearing. In view of this, my lord, understanding, my lord, the order passed. I said, my lord, this bail petition now, your lordships are hearing. I said, we will not press it. Now, my lord, this has been stayed by the honorable court. They took a U-turn, my lord, admitting everything here, my lord.
The order is state.
Yes, my lord. That is why my lord,
Where is that order?
my lord, it is 188. Lord, may I show one, my lord, one line, my lord, in this order, where, my lord, what made the apex court, my lord, para six, my lord, page 76, 176, my lord,
Page?
176.
No, 176 is the order passed by.
Yes, my lord, last one condition, my lord.
Yes,
In view of the fact that the petitioner has agreed to join the investigation, bail application, if any, to be filed by the petitioner shall not be opposed by the prosecution. This is a consensual order passed by Lordship, my lord, after hearing both the parties, balancing the interest of both the parties. Because I am a police officer. They are now the other police officers are behind me, and it is now CID and I am in other department. My lord, showing this order, my lord, this condition, they secured this interim order at 188. But above this, my lord, there are other conditions. So I'll come back, my lord, after showing this, my lord. Issue notice, my lord, responded returnable after 8 weeks. So and so senior counsel appearing for caveat. Then, my lord, in meantime, there shall be stay against the implementation of the impugned order. However, the respondent number 1 shall be at liberty to file a separate application seeking anticipatory bail, but bail before the concerned court. And if any such application is filed, the same shall be considered by the court on its own merits without being influenced by the impugned order passed by the High Court and or earlier rejection of the application. My lord, this is especially, my lord, there is one more matter where he has been arraigned as accused. That is second complaint on the same facts. He obtains, my lord, interim order in the first complaint. To overcome that, they register second complaint. And, my lord, they even went, my lord, and took proclamation against me, and showing proclamation, coordinate bench has rejected my bail petition. That is how, my lord, now liberty has been given to me. However, my lord, this undertaking is now stayed by the apex court.
no, we have given an undertaking that you will not press this petition.
Yes, my lord, this petition. Now your lordships are hearing. My lord, pursuant to this, my lord, interestingly, my lord, I appeared before the concerned IO 2 or 3 times, my lord, and I gave, my lord, bond and, my lord, surety also. That and the
But
car which is alleged to have been, my lord, dashed the complainant, that has been seized. That was in my wife's name, my lord, and that has been seized now. Now, at this stage, my lord, this matter is there. That's I just wanted to bring you.
But the Honorable Apex Court says that respondent number 1 shall be at liberty to file separate application.
That is in that matter, my lord, where in crime number 1 of 2024, where earlier bail was rejected, saying proclamation has been issued. My lord, when that bail petition was pending before the trial court, this incident alleged to have been taken place. My lord, kindly see, my lord, now again, my lord, I just come back to this order, my lord, of the coordinate bench in 482 petition, page 174, my lord.
But, additional SPP is not here.
Yes, my lord, I will bring. Pass on.
Now, my lord, I have executed the bond. Car has been seized. I have given statement also. Only my interest has to be safeguarded because, my lord, they may detain me in custody otherwise unnecessarily, my lord.
The order have appeared thrice and participated.
Who is the complainant?
My lord,
Who is the complainant?
complainant is a police officer. He says, my lord, when he tried to arrest him in the court premises, my lord, I tried to escape, and half he was inside the car, and I dashed the car, and with the intention to, my lord, commit his murder, my lord, I rashly drove car. This is the allegation. And there is a delay, my lord. They say, my lord, around 1 o'clock, the incident taken place. They lodged complaint at 7 o'clock. And the complaint is structured in a way that, my lord, it is a professionally, he tried to kill somebody. Complaint is, my lord, that page 26, annexure B is the complaint, my lord. Ali, ಎರಡನೇ page in 27 in the sakale. He received information that this person who is required in other case is waiting in the court, and therefore they went there and they tried to secure him, arrest him, is the narration of the story, my lord. Then, my lord, he was discussing with his advocate. At that time, they entered there.
Let him come.
Yes. But I just wanted to bring the background of the case, my lord.
First. Who is the petitioner?
Petitioners, my lord, accused number 1 and 2.
1 and 2.
1 and 2.
Are there any other accused?
No, only 2.
What are the offense?
307,
When you are arrested,
3/2/24.
charge sheet is filed.
Yes,
Where is it?
not yesterday I filed in the counter.
ಇದೆ.
The allegation, my lord, that accused number 1 and 2 assaulted the son of the complainant with chopper and head.
Your husband and wife.
Husband and wife. The son of the complainant having an affair with wife of the second petitioner. That is petition number 1. He engaged by the same, my lord, number 2 and 1 assaulted wife of the complainant.
Where is the own certificate?
Lord, page 24, typed copy at 25. 3 injuries, my lord, on the head.
Corresponding injuries are there.
There are injuries, my lord.
Machete was recovered at your instance.
Yes, ma'am. I do admit the incident, my lord, but my submission, my lord, that they were discharged, injured were discharged.
At the instance of both.
Please,
Machete was recovered at
Yeah,
whose
one.
instance?
A2,
A2.
A2. Lord, sir, they were discharged on 9/2/24. After taking treatment about 7 days 6 days in the hospital. They are out of danger, please.
Discharge Ram,
9/2/24,
9/2.
9/2. Admitted on 3/2/24.
Hmm.
Take treatment at 6 days, my lord. Now, my lord, they are out of danger.
Yes.
And my lord, now charge sheet is filed, my lord, investigation is completed.
Hmm.
The custody of the petitioners is, my lord, not required.
Criminal antecedents.
No answer.
Yes, what is it?
My lord, there is a serious allegation, my lord, assaulting, my lord, using the deadly weapon to the head of the deceased, my lord. That is the vital part of the, my lord. The accused number 1 and 2 both have assaulted, my lord, the head of the, my lord, the victim, my lord.
Injured himself is the complainant,
No, my lord. Sir.
the complainant.
Complainant is, my lord, the
Husband of the complaint.
husband of the
Sorry?
Husband of the injured.
husband. Specific overt act, my lord, is against, my lord, in the complaint itself, my lord, ಆಶಾಳು ಮಚ್ಚಿನಿಂದ ಮಮತಾಳ ಹಣೆ ಎಡಭಾಗಕ್ಕೆ ಹೊಡೆದಿರುತ್ತಾಳೆ. ನಂತರ ಮಹಾರುದ್ರೇಶನು, that is accused number 2, ಆಶಾಳ ಕೈಯಿಂದ ಮಚ್ಚನ್ನು ಕಸಿದುಕೊಂಡು ಮಮತಾಳ ತಲೆ ಹಿಂಭಾಗಕ್ಕೆ ಬಲವಾಗಿ ಹೊಡೆದು ರಕ್ತಗಾಯಪಡಿಸಿರುತ್ತಾನೆ. That is, my lord, specific allegation to the, my lord, vital part of the, my lord, the body, my lord. Therefore, my lord, considering the seriousness of the offense, my lord, all the injuries are, my lord, grievous injuries.
Only 2 injuries, not all.
No, 3 injuries.
Three injuries.
3 injuries
Three
are there, 2 and 3 are grievous.
No, 1, 2 and
1,
3.
2 and 3 are were grievous.
All the 3 are grievous in each.
Have a type
Yes, my lord, there is a fracture, I do admit, my lord. But the, my lord, at this stage, my lord, they are in custody for the last 2 months. And investigation is completed and charge sheet is filed. Injured, my lord, are out of danger. They are pursuing their daily activities as usual. Their custody, my lord, is not required. Offense is 307.
Petitioners who are read as accused number 1 and 2 are seeking grant of bail. They were apprehended on 3/2/2024 on the basis of the investigation lodged by the husband of the injured. Specific allegations are made against the accused for having assaulted the individual with a machete on her vital parts. The wound certificate discloses that 3 corresponding incised wounds were found, were sustained, and she was treated as an inpatient from 3/2/2024 till 9/2/2024. Admittedly, the injury is admittedly, the machete used in commission of the offense was recovered at the instance of accused number 2.
No, it was, my lord, was found on the spot.
Hmm?
Machu was found on the spot.
Admittedly, the machete was thrown at the spot and the same is already recovered. Next one. The investigation is concluded after apprehending the accused and the charge sheet is filed. Prosecution is relying on as many as 21 cases. Admittedly, the petitioners are not having any criminal antecedents. The trial in the matter may take sufficiently long period of time. And detention of the petitioners in custody amount to infringement of their right to life and liberty. Reasonable conditions may be imposed, so this is subject to conditional orders.
Please.
Here for petitioner. The serial number 8 in the second list, my lord. The same day it was posted, my lord, by oversight, my lord, notice was specifically not ordered, but the government sought time, my lord, learned friend appeared that in that matter.
Serial number 8.
The difference is, my lord, the serial number 8 ali, he is arraigned as accused, named in the FIR. But so far as this petition 4009, my lord.
We taken together, both the cases.
Yes.
First one, 4009. Remember. Yes, who is the petitioner in the first petition?
My lord, in the Lordships having, my lord, 4009 now.
Hmm.
That, my lord, petitioner, my lord, is not arrayed as accused in the complaint or, my lord, in the FIR. The offence alleged is, my lord, 66, 66C, 66D, and my lord, 153A, 120B, 419, 469, 471, 505, clause 2.
Who are the petitioners in the connected matter?
Connected matter, my lord,
Number
the
two.
accused number 2 is before your lordship. But the allegation is that, my lord,
Seven accused named in the,
in all, my lord, 7 accused are named in the FIR.
438.
please, both are under.
Both are under 438. And interim bail has been granted, my lord, during the vacation.
In which matter? In both the.
Both the matters. Even today, my lord, it is in. But page 15, my lord, page 22 is the complaint. But the complaint has been lodged by a political party, my lord, and its office bearer. Allegation is that, my lord, a fake news report, my lord, photo of a news report, which is alleged to be a fake one, has been posted by the some of the persons, my lord, in the social media. That has been shared by the petitioner. So far, the person who is not named, my lord, the allegation is that, my lord, he spoke about that in his media channel.
Complaint against in all how many persons?
7. Petitioner, my lord, in criminal petition number 3786 is accused number 2. Only allegation against accused number 2 is that, my lord, he has shared the said fake news, my lord, in social media. There is no allegation of manufacturing or my lord, creation or anything, lord. But the complaint is at page 22. ಟ್ವಿಟರ್, ವಾಟ್ಸ್ಆಪ್ ಹಾಗೂ ಫೇಸ್ಬುಕ್ ಜಾಲಗಳಲ್ಲಿ ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳ ವಿರುದ್ಧ ನಕಲಿ ಸೃಷ್ಟಿತ ಮಾಧ್ಯಮ ವರದಿಯನ್ನು ಶೇರ್ ಮಾಡಿರುವ ವಸಂತ ಗಿಳಿಯಾರು, ಪಾಂಡು, BSY ಸಪೋರ್ಟರ್ಸ್, ಬಿಜೆಪಿ ದಾವಣಗೆರೆ, ರಾತ್ರಿ ಗೋಶಾಲೆ, ರಾತ್ರಿ ವಾಟ್ಸಪ್ ಗುಂಪಿನ ಅಡ್ಮಿನ್ಗಳ ವಿರುದ್ಧ ಕಾನೂನು ಕ್ರಮ ಕೋರಿ. But the content of the alleged fake,
Yes.
this is, my lord, ಹಿಂದೂಗಳ ಅಗತ್ಯ ನಮಗೆ ಬೇಡ, ಮುಸ್ಲಿಮರ ಓಟು ಸಾಕು, ಮುಂದಿನ ಜನ್ಮದಲ್ಲಿ ಮುಸ್ಲಿಮರಾಗಿ ಹುಟ್ಟುತ್ತೇವೆ, ಮುಸ್ಲಿಮರ ಓಲೈಕೆ ಕುರಿತು ಬಿಜೆಪಿಯವರ ಟೀಕೆಯ ಬಗ್ಗೆ ತಲೆಕೆಡಿಸಿಕೊಳ್ಳಬೇಡಿ. ಸದರಿ ಪತ್ರಿಕೆ ವರದಿ ಎಂಬಂತೆ ಸೃಷ್ಟಿಸಿ ಹಾಕಲಾಗಿರುವ ಪೋಸ್ಟಿನಲ್ಲಿ ಆರೋಪಿಗಳು ಮುಖ್ಯಮಂತ್ರಿಗಳು ಅಧಿಕಾರಿಗಳೊಂದಿಗಿರುವ ಫೋಟೋವನ್ನು ದುರುಪಯೋಗಪಡಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ಅಲಿಗೇಷನ್ ಲಾಡ್ಜ್ಡ್ ಬೈ ಎ ಪೊಲಿಟಿಕಲ್ ಪಾರ್ಟಿ. Not there is no intention or, my lord, any ingredients of the offence list. All offences, my lord, are not triable by magistrate. My lord, there is no other incident or allegation. Only sharing is the.
Yes, what is?
Lord, of course, interim bail is granted. Lord, these allegations are reckless. Lord, of course, Article 19(2) has some reasonable restrictions.
Already election is over, results
Yes.
are out.
So therefore,
All these
of course,
cases will
Lord,
see its own
he
fate.
would submit no intentions. Intentions are writ large because it was before the elections. These are reckless allegations, Lord. It would encourage, Lord, ill will between the communities. Therefore,
Unfortunately, we see all such allegations
Yes.
on the both sides.
yes, of course, my
Yeah,
lord.
unfortunately.
Yes. The picture is edited of the CM, and it is shown that he is in an interview. He expresses these opinions saying that I wouldn't want any of the votes from Hindus. That I would want to be born as a Muslim. No, these are reckless allegations. He should not let scot-free
That
with
is-
these
that will-
allegations.
That will be tried by the.
Yes, of course,
magistrate.
motive and intentions are there. So therefore, some conditions that he would cooperate, because we would need to investigate his IP address, and that he runs a TV channel, a
Yes.
YouTube channel. by name Vikram. So it emanates from that YouTube channel and disseminates to the entire community, whereby ill will is.
But in fact, my lord, sorry.
So therefore, not since bail is already granted, conditions that he would cooperate and that he would not indulge in such offences anymore.
Generally, such conditions will be issued.
My lord, some specific that he would cooperate and my lord, on a 41A notice, he's come before this honorable court.
Yes.
And that he would, and his antecedents are also bad. He is involved in crimes which I have not narrated in my objection statement. That would be observed in the order, and then, my lord, with conditions.
How many cases are there against accused number 2, is it?
Yes, my lord, yes. Against accused number, this present petitioner, there are two.
Not against accused number.
There are two crimes registered against him. In crime number.
Where you have stated?
My lord, I'm filing my objection statement now, my lord.
Not filed yet.
Not filed. Your lordship may take it on record, and in that, I will.
Tell me crime number.
Crime number 322/2023, registered for offences under 504 and 506 by Jeevan Bhimanagar Police Station. Again, crime number 329/2017 for offence under 295A of IPC.
Who?
295A of IPC by Sanjay Nagar Police Station, Bangalore. And one more, my lord, CC number 677/2019. I will furnish the offences, my lord. It is under trial before the JMFC Bangalore. The specific court is not there.
Is it the very same 504, 506?
Not, I will, the offences are not detailed out. But these are his antecedents. So therefore, if that is observed, he will abide by the rule of law henceforth. That's all.
Lord, I appear for the impleading applicant, my lord, the first informant. I've filed application for intervention. Lordship permit, I'll make submission, not more than.
You can assist the.
I have filed my assist prosecution application, my lord.
Even I will allow that application, but you can only assist the prosecution.
All that I request.
Independent voice.
All that I request is, my lord, I have appended 2-3 documents in my assist prosecution application.
That may be looked into, my lord.
That may be looked into, and my, whatever learned SPP said, my lord, my apprehension is, that's all.
Third Learned Counsel, you have no objection for allowing
No.
Third Learned Counsel for the petitioner and the impleading applicant, counsel for impleading applicant on IA 3 of 2024. Senior advocate for the petitioner has no objection to allow the application. IA 3 of 2024 is allowed. Then counsel for the applicant is permitted to increase the prosecution.
Anyway, not to repeat the offense.
Petitioner in criminal petition number 4,
Cancellation of order.
2024 has approached the scope for grant of anticipatory bail on the option of being arrested, even though he is not again petitioner in criminal petition number 4020 of 2024 has filed similar petition as he is arraigned as accused number 2. Admittedly, in both these cases, interim bail was granted by the coordinate bench of this court. And there is no allegation that the conditions imposed while granting interim bail were violated. Next part. The state organizing secretary of KPCC filed the complaint against 7 persons, alleging the offences as stated above. It is the specific contention of the complainant that accused number 2 The petitioner in the second petition.
Yes,
Share the post in the social media. With, yeah, deliberately. With multiple intention. The edited photo of the chief minister with the fake news being spread in the society. Of course, the offenses are triable by the law of the state. It is contended by the learned SPP that accused number 2 is having criminal antecedents as crime number 322 of 2023 of G1 Bima Nagar Police Station for the offense punishable under section 504 and 506 was registered. And crime number 329 of 2017 for the offense under section 395 of 295A of IPC was registered here in Sanjay Nagar Police Station. But such criminal antecedents may not come in the way of granting anticipatory bail in the present case, as admittedly the petitioners are not required for the interrogation. Reasonable conditions may be imposed to take care of the interest of the prosecution while granting anticipatory bail. Accordingly, we said they are part. Allowed subject to conditions.
The objections may be taken on record, that's all. I only mentioned the crime
So,
numbers.
some first order sheet and then
Oblige.
HGP takes notice. Third, SPP, yes. IA pending, IA disposed of. IA 3 allowed hourly IP, yes.
Can you pass on? Pass on.
Pass over.
For petition, my lord. POCSO Act, my lord, 439 sole accused.
When arrested,
Arrested on 23/12/2023.
age of the victim,
14.5 years, my lord. Complaint is missing complaint.
complained by,
Mother of the victim, man. Miss ಆಗಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ. Investigation completed, charge sheet filed. Column number 17 of the charge sheet in page number 36 of my petition, mail. Page number 36 of my petition, column number 17 of the charge sheet. May permitted read, my lord. ಈ ದೋಷಾರೋಪಣಾ ಪಟ್ಟಿಯ ಕಲಂ ನಂಬರ್ 14ರಲ್ಲಿ ನಮೂದಿಸಿರುವ ಸಾಕ್ಷಿ 1 ರವರು ಜ್ಞಾನಭಾರತಿ ಪೊಲೀಸ್ ಠಾಣಾ ಸರಹದ್ದಿಗೆ ಸೇರಿದ ಉಲ್ಲಾಳು ಮುಖ್ಯ ರಸ್ತೆ ವಿದ್ಯಾನಿಕೇತನ ಶಾಲೆಯ ಎದುರು RTO ರಸ್ತೆಯಲ್ಲಿರುವ ಮನೆ ನಂಬರ್ 2ರ 1ನೇ ಮಹಡಿಯ ಮನೆಯಲ್ಲಿ ಸಂಸಾರ ಸಮೇತ ವಾಸವಾಗಿದ್ದಾರೆ. ಇವರಿಗೆ ಸಾಕ್ಷಿ 2 ಸಾಕ್ಷಿ 14 ವರ್ಷ 6 ತಿಂಗಳ ಎಂಬ ಮಗಳಿದ್ದು ಈಕೆ ಪ್ರಕರಣದ ನೊಂದ ಬಾಲಕಿಯಾಗಿರುತ್ತಾರೆ. ದೋಷಾರೋಪಣಾ ಪಟ್ಟಿಯ ಕಲಂ ನಂಬರ್ 12ರಲ್ಲಿ ನಮೂದಿಸಿರುವ ಆರೋಪಿಯು ಈ ಹಿಂದೆ ಸಾಕ್ಷಿ 1 ರವರು ವಾಸವಾಗಿರುವ ಬಿಲ್ಡಿಂಗ್ನ ಮತ್ತೊಂದು ಮನೆಯಲ್ಲಿ ವಾಸಿಸುತ್ತಿದ್ದು ಆರೋಪಿಯು ಸಾಕ್ಷಿ 1 ಮತ್ತು ಇವರ ಕುಟುಂಬದವರಿಗೆ ಪರಿಚಯಸ್ಥನಾಗಿದ್ದನು. ನೊಂದ ಬಾಲಕಿ ಸಾಕ್ಷಿ 2 ರವರ ಜೊತೆ ತುಂಬಾ ಆತ್ಮೀಯತೆ ಮತ್ತು ಸಲಿಗೆಯಿಂದ ವರ್ತಿಸುತ್ತಿದ್ದನು. ಹೀಗೆ ಸುಮಾರು 1.5 ವರ್ಷದಿಂದ ಆರೋಪಿಯು ಜ್ಞಾನಭಾರತಿ ಪೊಲೀಸ್ ಠಾಣಾ ಸರಹದ್ದಿಗೆ ಸೇರಿದ ಉಲ್ಲಾಳು ಮುಖ್ಯ ರಸ್ತೆ ಮುನೇಶ್ವರ ನಗರ 8ನೇ ಕ್ರಾಸ್ AR ಗಾರ್ಮೆಂಟ್ಸ್ ಹತ್ತಿರ ಇರುವ ಬಿಲ್ಡಿಂಗ್ ನಂಬರ್ 57 ಬಸವೇಶ್ವರ ನಿಲಯದ 2ನೇ ಮಹಡಿಯಲ್ಲಿರುವ ಮನೆಯಲ್ಲಿ ತನ್ನ ತಾಯಿಯ ಜೊತೆ ವಾಸವಾಗಿರುತ್ತಾನೆ. ಹೀಗೆ ಸುಮಾರು 1 ವರ್ಷದಿಂದ ನೊಂದ ಬಾಲಕಿ ಸಾಕ್ಷಿ 2 ರವರು ಆಗಾಗ ಆರೋಪಿಯ ಮನೆಗೆ ಹೋಗುತ್ತಿದ್ದು ವಿಕ್ಟಿಮ್ herself is going. ಆರೋಪಿಯು ಮನೆಯಲ್ಲಿ ಒಬ್ಬನೇ ಇರುವ ಸಮಯದಲ್ಲಿ ಸಾಕ್ಷಿ 2 ರವರಿಗೆ ನಾನು ನಿನ್ನನ್ನು ತುಂಬಾ ಪ್ರೀತಿಸುತ್ತಿದ್ದೇನೆ, ನಿನ್ನನ್ನೇ ಮದುವೆ ಮಾಡಿಕೊಳ್ಳುತ್ತೇನೆ ಎಂದು ಪುಸಲಾಯಿಸಿ ಸೋನ್ಸೋ ಹೀಗೆ 6 ತಿಂಗಳ ಹಿಂದೆ ಒಮ್ಮೆ ಸಾಕ್ಷಿ 2 ರವರು ಆರೋಪಿ ಮನೆಯಲ್ಲಿದ್ದಾಗ ಆರೋಪಿಯ ಮನೆಯಲ್ಲಿ ಒಬ್ಬನೇ ಇತ್ತು. ಆಗ ಆರೋಪಿಯು ಸಾಕ್ಷಿ 2 ರವರನ್ನು ನಾನು ನಿನ್ನನ್ನು ಪ್ರೀತಿಸುತ್ತಿದ್ದೇನೆ ಎಂದು ಪುಸಲಾಯಿಸಿ ಸಾಕ್ಷಿ 2 ರವರು ಬೇಡವೆಂದರು ಸೋನ್ಸೋ ಅಂತ ಹೇಳಿ ಅಲಿಗೇಷನ್. ದಟ್ ಇಸ್ 6 months ಬ್ಯಾಕ್. ಆ ನಡುವೆ ಆ 6 ತಿಂಗಳಿಂದ ಇವ್ರ ನಡುವೆ ಅನೈತಿಕ ಸಂಬಂಧ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತೇಳಿ ಅಲಿಗೇಷನ್ ಸರ್. ವಿಕ್ಟಿಮ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿಲ್ಲ, ಆಮೇಲೆ ಇವ್ರು ಓಡೋಗ್ತಾರೆ, ಆನಂತರ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದು ಸರ್. Page number 47 of my petition, medical report, my lord. Page number 47 of my petition, medical report about Ayman nil ಅಂತ ಬರ್ತದೆ.
ಏನಾಗಂದ್ರೆ
ಏನು ಬರ್ದಿಲ್ಲ, ಇವೆಲ್ಲ ಟೋಟಲ್ ನಿಲ್ ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
ಏನಾಗಂದ್ರೆ ಏನು ಅಂತ
ಐಮನ್ ಬಗ್ಗೆ ಏನ್ ಹೇಳಿಲ್ಲ ಅವರು, ಏನಾಗಿದೆ ಅಂತ.
ಅದ್ರ ಇಫೆಕ್ಟ್ ಏನ್ರಿ? That is against you, the finding is against you. ನಿಲ್ ಅಂದ್ರೆ ನಿಮಗೆ ಫೇವರ್ ಅಲ್ಲ, that is against you.
ಪ್ಲೀಸ್. 6 ತಿಂಗಳಿಂದ ಈಗ ಗೊತ್ತಿತ್ತು ಅವ್ರಿಗೆ, ಮೊದಲೇ ಎಲ್ಲ ಮನೆಯವ್ರಿಗೆಲ್ಲ ಗೊತ್ತಿತ್ತು ಸ್ವಾಮಿ ಇದು.
She is a minor, sir.
Please.
14 years old.
ಪ್ಲೀಸ್.
No, not entitled. Yes.
164 also, my lord, she has stated, my lord, she has, the petitioner has committed, my lord, forcible sex, my lord, on the.
No, not entitled.
With liberty to after examination of the victim, my lord.
Hmm?
With liberty after victim examination ಅಂತ ಹೇಳಿ.
ಏನು, you are withdrawing the
Please.
counsel for the petitioner after addressing the argument for some seeks permission to withdraw the petition with liberty to file similar petition before the trial court after examination of material witnesses. This submission is placed on record, petition dismissed with liberty is paid. Yes.
Petitioner.
Present respondent number 2 minutes.
Petitioner is a de facto complaint, my lord.
Petitioner,
Petitioner is a de facto complaint. Cancellation of bail, madam.
de facto
De facto complaint, madam. Petitioner,
complainant,
de facto,
no, cancellation.
cancellation.
How many accused?
Accused number 1 to 5, my lord. Respond number 2 to 5 of the accused.
1 to 4.
1 to.
What are the offense?
The offense is 419, 420, 465, 468, 471, 504, 506, 34, my lord. At page number 32, my lord. But I have made an application, my lord, for advancement on 18/4/2024, my lord. But page number 32, my lord. I filed an advance on the application, my lord. And also application section 301 subclass 2 of CRPC, my lord,
Is to advance the noted case.
to consider the arguments of the de facto complaint, my lord. The London Session Judge, my lord, they posted the matter for 28th, my lord. When the day, on that day, the matter was posted for orders, my lord. But next page, my lord. Page number 24, my lord. On date of the pronouncement of order, my lord, my application has been disposed, my lord.
Where is the order?
24, page number 24. Para number 2, my lord. (18/4/2024), my lord. So IA under section 309 CRP seeking advancement of the case along with IA under section 301 of 2 subclass 2 CRPC about on account of the complaint of under
Earlier they 409.
para 2, page number
Para
2,
two,
para 2. On 18/4/2024, so under section 309 of CRPC seeking advancement of the case along with IA
under section 301 subclass 2 of CRPC and Wakalat of the complaint of crime number so and so, praying court to give him opportunity to address the arguments.
Yes.
The case was already reserved for orders, therefore the case cannot be preponed at any cost except the pronouncement of orders. Secondly, the offense are trialable by Leonard JMFC. The matter relates to sale agreement, therefore it is not fit case this court to exercise discretion power confirmed under section 301 of subclass 2 of CRPC and to permit the complaint to address his grievances. The Supreme Court judgment not in the existing.
You are aggrieved by this?
Yes, ma'am.
You are aggrieved by this order?
That is the challenge, madam.
Sorry, my lord, challenge is to the grant of bail, not to this order.
My order, my lord, I will submit the.
No, you are seeking cancellation of
Cancellation of
bail.
bail.
Where is the order granting bail?
Order granting bail is in page number.
Where is it?
Fourteen. Fourteen is the order.
No, what is your grievance?
My grievance is that, my lord, my application has not been considered as per Supreme Court judgment, my lord.
What is? ಏನಿದೆ ಇದರಲ್ಲಿ?
Page 18, my lord.
Yes.
Para 15, man. Having heard to senior counsel for the parties considerable, we find the following questions fall of our consideration. Whether victim is defined under section 2AA of CRPC.
Page number 18.
Sorry, 8 minutes. Sorry, 8 minutes. 8 minutes. Whether victim as defined under section 2AA of CRPC is entitled to heard at the stage of adjudication of bail application of an accused. Whether the High Court overlooked the relevant consideration while passing, implying and order granting bail to the respondent accused. If so, whether the High Court's or order dated 10 to 2/2020 is bailable, illegal and warrants interference by this court. So victim right to be heard.
Yes.
But until recently, criminal law had been viewed in demonstrative plane, wherein the courts were required to adjudicate between the accused and the state. The victim, the de facto suffers to crime, had no participation in adjudicated process and was made to sit outside the court as mute speculator. However, with recognition the ethos of criminal justice dispensation to prevent and punish the crime had sufficiently turned into back on the victim. The jurisprudence with the respect of to rights of the victim to be heard to participate in the criminal proceedings began to positive.
Where it is answered, page number?
Page number 8. Next to continue page number 9.
No, answer to question number 1.
Para 16.
Page number?
Same continues from para 16.
So there the following questions will fall for consideration. Where is the answer? Come to page, para number 44, page number 23.
44.
Hmm.
Needless to say, the bail application shall be decided.
So this is the only ground.
Yes, ma'am.
You are not given an opportunity of
Opportunity,
being
ma'am.
heard.
So far, my lord, concerned the petitioner, but he is having other cases, my lord, pending.
Hmm?
Other cases, my lord. He is having involved in other criminal cases, 420, 468, my lord. I produced the document.
Yes. It is.
It's, first and foremost, my lords, is this order which was pointed out at page 24, my lords. This is not subject matter of challenge here, my lords. The prayers which have been done here is only for cancellation of bail, and this order which was passed by the learned judge while considering 301 subsection 2, my lords, that has not been challenged at all. Now, my lords, yes, my lords, I will come to it. My lords, on the main matter itself, my lords, the offences which have been alleged are all offences punishable with less than.
The learned magistrate could have heard the complainant, the
But-
victim.
Yes, my lord, not after the orders are reserved. My lords, in my respectful submission, my lords, once a matter has been heard and it is posted either for judgment or orders, at that point of time, no application can be entertained itself, my lords, because the court.
Those technicalities in a criminal case, that too when the bail applications are being heard. We are allowing you to do so many things.
But my lords,
We are going to by two technicalities.
my lords, let's look.
It will frustrate
My lords,
the
could
end
I,
of justice.
my lords, could I make this request? Now the parties are here. They will have to point out whether the discretion used is wrong or not, my lords. If
This
the
is the only thing, without affording an opportunity.
Well,
to
that
the
may
victim.
not, that alone may, in my respectful submission, my lords, that alone may not be a ground unless they show that the matter requires interference because the discretion exercise was wrong. Now, if the discretion exercised in a matter, my lords, where two civil suits are pending between the parties, there's injunctions granted in the court, then the criminal law is set in motion. I have filed a 482 petition for quashment of the entire proceedings. That is when, my lords, this cancellation of bail is filed. My lords,
To the.
it is
482.
pending.
No, my lord,
480
yesterday the matter was
I'm
posted, my lord.
could I-
And I submitted before the court.
Let him
Ah,
make-
bless,
Well,
please.
it's when my 482 petition came up for admission the first time, they would appear even before notice and say, we will want to have a say in the matter. Matter is pending consideration before the coordinate bench, my lords,
Yes.
where we have sought for quashing of the entire proceedings. This entire allegation which they make, my lords, is on an agreement of sale, my lords. They say an agreement of sale is purportedly fabricated. This is their whole case, my lords. That agreement of sale is subject matter of a suit for specific performance pending before the civil court, where there's an interim order of injunction granted
In your favor.
in my favor. When it is subject, and also, my lords, one more suit where we had sought for a bare injunction.
You are the agreement holder,
I am the agreement holder, my lords.
to the owner.
My lords, complainant is the owner. Now, complainant says, my lords, that agreement which they have, because after entering into an agreement of sale with me, he enters into an agreement of sale with another person. So then, my lords, when we file the suit, his contention is no, that first agreement is a fabricated document. And that is subject matter of a specific relief suit. This is it, my lords. Ultimately, all these offences, my lords, are offences punishable with less than 7 years. So Anthil's case, category A, my lords, discretion to be exercised in favor of an accused, my lords. And that is when, my lords, when the matter was completely heard and reserved for orders, then they come and file this application under 301 subsection 2.
Yes.
So even on the merits of it also, my lords, it's a case, my lords, where matter is to be tried by a magistrate, my lords, and less than 7 years of, and civil suits pending.
Yes, what do you
But-
say regard on merits?
Merits, my lord, they
You are the
still,
owner of the property.
I am the owner of the property. I have not executed any the signatures, my lord.
Yes, suit is pending.
Suit,
for
my lord,
specific
immediately, my lord, immediately they filed the suit. After forging the documents, immediately they made,
performance.
yes, my lord. What happened, my lord?
The interim order of injunction is granted.
Yes, ma'am, they have filed the injunction suit. First, my lord, they made a forged document, my lord. They took the paper at midnight at 11:49 PM, my lord.
No.
The signatures have been forged, my lord.
Allegations are there.
They're not.
Forgery, cheating, everything is there.
They're not.
Then
So immediately, my lord, they filed the civil suit. They escaped from the criminal liability, my lord. They filed the civil suit and original documents, all they kept in the
Now-
civil court, my lord.
now we have the reasons assigned by the learned sessions judge for allowing their application.
Yes.
Why you are saying that it is, why you are challenging that order?
But my order, my lord, if 18th I made an application, my lord, on that day itself, it has been
Sir,
dismissed.
now I am hearing you, you can make out a ground,
But he forged the documents, my lord.
forged, yes. That is agreement for sale.
Agreement first.
I feel.
And he has a, the accused number, petitioner number one, my lord, he is having a criminal case, my lord. I
What
produced
is
the
that
documents.
Petitioner, number one is having
He has having criminal cases, my lord.
how many?
2 cases, my lord.
Which are those?
Crime number 110/2012, my lord.
Crime number?
110/2012.
Where?
419, 420, 465, 468, 471.
Of which police station?
Of same.
Which police station?
Malur police station.
Then
Then my crime number 5/2019, my lord.
5/19.
323, 504, 506, read with 34 of IPC. 323, 504, 506, read with 34 of IPC.
Which police station?
It's a Vemgal police. Ma'am.
Huh?
Vemgal police, ma'am. Kolar district.
Hmm.
2 cases are.
Yes. Yes, that's all. The conditions impose ಮಾಡಿದಾರಲ್ಲ.
ಮಾಡಿದ್ದಾರೆ.
Reasonable conditions are imposed. None of the conditions were violated or disobeyed.
What happened, my lord, when I filed an application, but they not given opportunity. On that ground, I before this on court, my lord.
So the grounds now you are urged is not sufficient to cancel the bill.
I'm not, my lord. Only on this, based on Supreme Court judgment, not that opposition should be given fair
Yes, sir,
opportunity.
now I have heard you.
Not on merits of the case.
I have already heard you. It is not a ground for recalling the bail granted or cancelling the bail.
But on date of 18th, my lord, 18th itself, it has been dismissed, my application. I could have come before this court, my lord.
Learn counsel for the petitioner. Submits that he had filed an application under section 309 of CRPC before the learned session stage, saying to advance the matter and to hear him before passing the order in a criminal miscellaneous number 309 of 2024. But the said application was to be dismissed by the learned magistrate today order dated 24/2024 on the ground that the matter is already reserved for orders. Therefore, it is clear that the petitioner being the victim as defined under section 2WA of CRPC is not given an opportunity of opposing the bail application filed by responding numbers 2 to 5. Therefore, the bail granted by the learned sessions judge in the above criminal miscellaneous petition with a order dated 20th April 2024 is liable to be cancelled. Per contra, it is the contention of the learned senior advocate for responding 2 to 5 and the learned HCGP that the dispute between the parties is purely of civil nature. The respondents are relying on an agreement for sale. It was executed by the petitioner as owner of the land. Petition respondents have filed the suit for specific performance of the contract, which is pending consideration before the civil court. An interim order of temporary injunction was granted in favor of the respondents and against the petitioner. In the meantime, the present complaint was going to be filed, making false allegations A 482 petition is also filed before this court, taking question of the criminal proceedings. Considering all these facts and circumstances, the learned sessions judge rightly granted the anticipatory bail, imposing reasonable conditions. Next. It is contended by the learned counsel for the petitioner that the petition number 1 is having criminal antecedents. Petition number 1, respondent number 2 is having criminal antecedents as crime number 110 of 2012 of Malur Police Station for the offense punishable under section 419, 468, etc. And crime number 5 of 2019 of Vemagal Police Station for the offense under 323.6 is also pending. But the fact remains that the learned sessions judge, even though rejected the application filed by the petitioner and had not offered an opportunity to him, considered the bail application filed by the respondents on merits after considering the civil suit pending in OS 134 of 2024 filed by the respondents against the petitioner hearing, seeking specific performance of the contract and the delay of 2 months in filing the first information in the present case. Conditional order of anticipatory bail was granted. It is not the contention of the petitioner that any of those conditions imposed on the respondents were either violated or disobeyed. I do not find any patent illegality in the order granting anticipatory bail. When there is no illegality or perversity in the order granting anticipatory bail, and when the respondents have not violated any of the conditions imposed while granting anticipatory bail, I do not find any reason to cancel the bail. Contention of the learned counsel for the petitioner, since he was not given an opportunity of being heard before passing the order granting anticipatory bail, the same needs to be cancelled, cannot be accepted, as cancellation of the bail will have the serious consequence of interfering with the liberty given to the respondents by the learned session, by the order of the learned session judge, which cannot be found fault with. Therefore, I am of opinion that counsel for the petitioner placed reliance on the decision of the Honorable Apex Court in Jagjit Singh and others versus Ashish Mishra alias Mono and another to contend that the victim defined under CRPC is entitled to be heard at the time of adjudication of the bail application of the accused. Yes. Petition dismissed.
Glazed. Petitioner Miller. Petition Miller. POCSO Act. Victim is aged about 16 years, 11 months, 23 days. Father of the victim is the complainant in this case, Miller.
Sole accused.
Yeah.
Sole accused.
Sole. ಅಲ್ಲ ಅಕ್ಕಿ ನಂಬರ್ 2 to 5 ಇರ್ತಾರೆ, ಅವ್ರನ್ನ ಚಾರ್ಜ್ ಶೀಟ್ ಕೈ ಬಿಡ್ತಾರೆ, ಅವ್ರ ವಿರುದ್ಧ ಯಾವುದೇ ಆರೋಪ ಸಾಬೀತಾಗಿಲ್ಲ ಅಂತ ಹೇಳಿ.
Now you are the sole accused.
Please.
When you are arrested,
Arrested on 6/2/2024.
father is the complainant.
Please,
Charge sheet is filed.
file me. Column number 17 of the charge sheet in page number 36 of my petition. ನ್ಯಾಯಾಲಯದ ವ್ಯಾಪ್ತಿಗೆ ಸೇರಿದ ನೆಲಮಂಗಲ ಗ್ರಾಮಾಂತರ ಪೊಲೀಸ್ ಠಾಣಾ ಸರಹದ್ದಿನ ನೆಲಮಂಗಲ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಬಾವಿಕೆರೆ ದಾಖಲೆ ಬಸವನಗರ ಗ್ರಾಮದಲ್ಲಿ ವಾಸವಾಗಿರುವ ಸಾಕ್ಷಿ ಒಂದೂರವರ ಮನೆಗೆ ದೋಷಾರೋಪಣಾ ಪಟ್ಟಿ ಕಲಂ ನಂಬರ್ 12ರಲ್ಲಿ ಕಂಡ 1ನೇ ಆರೋಪಿ ಕಳೆದ 3 ವರ್ಷಗಳಿಂದ ಆಗಾಗ್ಗೆ ಸಾಕ್ಷಿ ಒಂದೂರವರ ಮನೆಗೆ ಬಂದು ಹೋಗುತ್ತಿದ್ದು, ಆ ಸಮಯದಲ್ಲಿ 1ನೇ ಆರೋಪಿ ಮತ್ತು ಸಾಕ್ಷಿ ಒಂದೂರವರ ಸುಮಾರು 17 ವರ್ಷ ವಯಸ್ಸಿನ ಅಪ್ರಾಪ್ತ ವಯಸ್ಸಿನ ಮಗಳಾದ ಸಾಕ್ಷಿ 2ರವರ ನಡುವೆ ಸ್ನೇಹವಾಗಿದ್ದು, ನಂತರದ ದಿನಗಳಲ್ಲಿ ಇಬ್ಬರು ಪರಸ್ಪರ ಪ್ರೀತಿಸುತ್ತಿದ್ದರು. ಹೀಗಿರುವಾಗ 6 ತಿಂಗಳ ಹಿಂದೆ ಒಂದು ದಿನ ಮಧ್ಯಾಹ್ನದ ಸಮಯದಲ್ಲಿ 1ನೇ ಆರೋಪಿ ಬಾವಿಕೆರೆ ಗ್ರಾಮದಲ್ಲಿರುವ ತನ್ನ ವಾಸದ ಮನೆಯಲ್ಲಿ ಯಾರೂ ಇಲ್ಲದ ಸಮಯದಲ್ಲಿ ಸಾಕ್ಷಿ 2ರವರನ್ನು ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಸಾಕ್ಷಿ 2ರವರನ್ನು ಸೋಣಸೋ ಮುಂದೆ ಮದುವೆ ಆಗುತ್ತೇನೆಂದು ಪುಸಲಾಯಿಸಿ ಬಲಾತ್ಕಾರ ಮಾಡಿರುತ್ತಾನೆ. ಅದೇ ರೀತಿ 1ನೇ ಆರೋಪಿ ಅವರ ಮನೆಯಲ್ಲಿ ಯಾರೂ ಇಲ್ಲದ ಸಮಯದಲ್ಲಿ C2 ಅವರನ್ನು ಕರೆದುಕೊಂಡು ಹೋಗಿ 4-5 ಬಾರಿ ಈ ರೀತಿ ಅತ್ಯಾಚಾರ ಮಾಡಿರುತ್ತಾನೆ. ಕಳೆದ 4 ತಿಂಗಳಿಂದ ಪೀರಿಯಡ್ ಆಗಿಲ್ಲ ಅಂತೇಳಿ ಹಾಸ್ಪಿಟ್ಲ್ಗೆ ಹೋದಾಗ she came to know that she is pregnancy ಅಂತೇಳಿ ಸರ್.
Yes.
ವಿಕ್ಟಿಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮೇಡಮ್. ವಿಕ್ಟಿಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ ಸರ್.
In 164.
164 ಬಗ್ಗೆ ಎಲ್ಲೂ ಇಲ್ಲ, ಅವ್ರ ಹತ್ರ ಇರ್ಬೋದು, ನಮ್ಗೆ ಕಾಪಿ ಸಿಕ್ಕಿಲ್ಲ ಸ್ವಾಮಿ.
Why you are relying on this? Why you are relying on this statement?
ಆ ಸ್ಟೇಟ್ಮೆಂಟ್ ವಿಕ್ಟಿಮ್ ಹೇಳಿರೋದು ಪೊಲೀಸರ ಮುಂದೆ. ಪರಸ್ಪರ ಪ್ರೀತಿಸ್ತಿದ್ರು. ಆಮೇಲೆ
It is a minor.
ಪ್ಲೀಸ್
Hmm.
17
You
years.
cannot say that it is with consent.
Please, she's under 17 age.
Maybe. ಆಗಲ್ಲ.
ಅವ್ರ ಸಂಬಂಧಿಕರೇ ಅಂತೆ ಅವರೆಲ್ಲ.
No, not entered. Okay.
ಓಕೆ, ವಿತ್ಡ್ರಾ ಮಾಡ್ತೀನಿ ಮೇಡಮ್.
Hmm.
ವಿತ್ ಲಿಬರ್ಟಿ ಟು ಆಫ್ಟರ್ ವಿಕ್ಟಿಮ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಂತ ವಿತ್ಡ್ರಾ ಮಾಡ್ತೀನಿ.
Counsel for the petitioner after addressing the arguments person. His permission with liberty ಅದೆಲ್ಲ. Yes, dismissed with liberty.
For petition 376. 368. The 4 and 6 of a POCSO Act.
Hmm.
Missing complaint filed by the mother earliest point of time. Thereafter, my lord,
Age of the victim.
16 years, 4 months, 22 days. And the time of filing the petition, I have not produced the medical certificate, my lord. Am I permitted to produce? Kindly first instance, my lord, kindly see the in medical certificate. Both are allowed to.
Hmm.
Parrot, page number 2, madam.
Hmm.
History for the first instance. The last time, my lord, both had eloped from the Arsikere by walking to Tiptur. They have.
Maybe, but she is still a minor.
It's a 17. She herself stated, my lord, she had a love affair.
Sir, how can you attribute anything
It's
to the minor?
Below 16 years, it's
She's
above
16
16 years. Above 16 years, my lord.
16 years ಅಷ್ಟೇ.
And 16 years, 17 years running, my lord. And her statement in the first instance, my lord, both had sexual intercourse with consent. And nature, my lord, they.
Is it a defense under POCSO Act?
No.
Can you attribute consent on the part of a minor? That too age 16 years. ಅಷ್ಟೇ simple. 17 years, 17 plus something.
It's a 17-year running, my lord. So 16 years completed.
16, 17 ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. 16 means 16.
Permit to withdraw the my lords after completion of the victim's evidence.
First, ಅದನ್ನೇ ತಗೊಳ್ಳಿ. After addressing the argument person, seeks permission to withdraw the petition with liberty to file similar petition before the trial court for examination of material witnesses. Submission is dismissed. Next.
439, my lord. Offense 306. This is the wife, my lord. Sachet has been filed. My lord. The accused,
Petitioner is the
sole accused, husband, my lord.
husband.
The accused is proceeded
He was arrested
18/1/2024, my lord.
18/1.
18/1/2024.
Date of incident
17, my lord.
who is the complainant?
Brother of the deceased. The accused is a processed on two sites the site has been registered in our favor. The
Where is
accused,
the charge sheet, sir?
charge sheet, my lord,
Column
page
number
28, my lord, column number 17,
29.
28.
Hmm.
4 ವರ್ಷಗಳಿಂದ ಆರೋಪಿತನು ಯಗವುಕೋಟ ಗ್ರಾಮದಲ್ಲಿ 2 ನಿವೇಶನಗಳನ್ನು ಖರೀದಿಸಿ ಅದರ ಪೈಕಿ ಒಂದು ನಿವೇಶನವನ್ನು ಮೃತ ರಾಧೆ ಅವರ ಹೆಸರಿನಲ್ಲಿ ಮಾಡಿರಿಸುತ್ತಾರೆ. ನಂತರ ಆರೋಪಿತನಿಗೆ ಹಣಕಾಸಿನ ತೊಂದರೆಯಾದ ಕಾರಣ ಆರೋಪಿತನು ಮೃತ ರಾಧೆಯರ ಹೆಸರಿನಲ್ಲಿರುವ ನಿವೇಶನವನ್ನು ಮಾರಾಟ ಮಾಡು, ನನಗೆ ಹಣಕಾಸಿನ ಅವಶ್ಯಕತೆ ಇದೆ ಎಂದು ಕೇಳಿದಾಗ ಮೃತ ರಾಧೆಯ ತನ್ನ ನಿವೇಶನ ಮಾರಾಟ ಮಾಡುವುದಿಲ್ಲ ಎಂದು ಹೇಳಿದ್ದು, ಅದಕ್ಕೆ ಆರೋಪಿತನು ಆಗಾಗ ರಾಧೆಯ ಮೇಲೆ ಗಲಾಟೆ ಮಾಡಿ ನೀನು ನಿವೇಶನ ಮಾರಾಟ ಮಾಡು, ಇಲ್ಲ ಅಂದರೆ ಎಲ್ಲಿಯಾದರೂ ಹೋಗಿ ಸತ್ತು ಹೋಗು ಎಂದು ಸಾಯುವಂತೆ ಪ್ರೇರೇಪಿಸುತ್ತಿದ್ದು, ದಿನಾಂಕ 15/1/2024 ಮತ್ತು 17/1/24 ಆರೋಪಿತನು ನಿವೇಶನವನ್ನು ಮಾರಾಟ ಮಾಡುವ ವಿಚಾರದಲ್ಲಿ ಮೃತ ರಾಧೆಯವರ ಹೆಸರಿಗೆ ಮಾನಸಿಕವಾಗಿ ಮತ್ತು ದೈಹಿಕವಾಗಿ ಹಿಂಸೆ ನೀಡಿ ನಿವೇಶನ ಮಾರಾಟ ಮಾಡು, ಇಲ್ಲ ಅಂದರೆ ಎಲ್ಲಾದರೂ ಹೋಗಿ ಸತ್ತು ಹೋಗು ಎಂದು ಸಾಯುವಂತೆ ಪ್ರೇರೇಪಿಸಿ ಗಲಾಟೆ ಮಾಡೋದ್ರಿಂದ ಮೃತ ರಾಧೆಯ ತನ್ನ ಮಕ್ಕಳಾದ ಪೂರ್ವಿಕಾ ಮತ್ತು ಹೆಸರಿಡದ ಒಂದು ಹೆಣ್ಣು ಮಗುವನ್ನು ಕರೆದುಕೊಂಡು ದಿನಾಂಕ 17/1/24 ಮನೆಯಿಂದ ಹೊರಟು ತವರು ಮನೆ ಬಾಗೇಪಲ್ಲಿಗೆ ಹೋಗುವುದಾಗಿ ಹೇಳಿ ಬಂದು ಮಿಟ್ಟೇಮರಿ ಗ್ರಾಮದ ಕೆರೆಯ ನೀರಿನಲ್ಲಿ ಮಕ್ಕಳೊಂದಿಗೆ ಬಿದ್ದು ಮೃತಪಟ್ಟಿರುವುದು ಆರೋಪಿತನ ವಿರುದ್ಧ ಕಲಂ 306 ಎಂದು ಆರೋಪಿಸಲಾಗಿರುತ್ತದೆ.
Happened to the children?
There are 3 children, my lord. The minor 2 children along with drawn the lake along with 2 kids.
So death of in all 3.
3, my lord. The incident has taken place at our parents' house, my lord.
Parents house ಇಲ್ಲ ಹೋಗಿಲ್ಲ ಅವ್ರು.
Yes, my lord, parents' house.
ಎಲ್ಲಿದೆ?
Last line, madam.
ಹೋಗುವುದಾಗಿ ಹೇಳಿದ್ದಷ್ಟೇ.
ಹೇಳಿ incident has taken place at Mittemari Grama. Mittemari Grama is our parents' house, my lord.
Yes.
My lordship, the charge sheet, it has clearly mentioned, my lordship. ಮೃತೆ ರಾಧಳಿಗೆ 3 ಜನ ಹೆಣ್ಣು ಮಕ್ಕಳಾದ ಕಾರಣ ಆರೋಪಿತನು ಮೃತೆ ರಾಧಳಿಗೆ 3 ಜನ ಮಕ್ಕಳು ಹೆಣ್ಮಕ್ಳಿದ್ರು ಅಂತ ಮಾನಸಿಕವಾಗಿ ಮತ್ತು ದೈಹಿಕವಾಗಿ ಚಿತ್ರಹಿಂಸೆ ನೀಡಿ ಗಲಾಟೆ ಮಾಡುತ್ತಿದ್ದು ಅಂತ ಇದೆ, my lordship. Even in the statement of CW-27 also, my lordship, that statement is not with me, my lordship. In the Sessions Court order, my lordship, page number 99, my lordship. The statement of CW-27 Nagamma, a neighborer, reveals that the deceased informed the alleged harassments to her and she witnessed the incident took place on 17/1/2024 at the house of the accused.
Yes, there are prima facie materials, but why he is to be detained in custody? Investigation is already completed. 306 is the offense. It is not 302.
One more minor child is there, ma'am.
Conditional. Petitioner being the accused, seeking grant of bail. He was apprehended on 18/1/2024. It is alleged that he married the deceased about 8 years back. and he was entreating the deceased by demanding to sell the site which is standing in her name. He instigated her to die. The deceased was unable to withstand his ill treatment. Jumped into the lake along with her 2 children and committed suicide. After the father of the deceased, the brother of the deceased lodged the first information. The petitioner was apprehended. Investigation is completed and charge sheet is filed. There are strong prima facie materials against the petitioner for having committed the offense. But it is not the case of the prosecution that the petitioner is required for any other purpose except to ensure his presence before the judge. Reasonable conditions may be imposed to safeguard the interest of the prosecution. If his detention in custody would amount to so and so. Allowed subject to conditions.
I represent Anticipatory. That application section 438. Malad, in all, there are 6 accused. Out of them, Malad, the petitioner before Lordship is accused number 1. Malad, according to the prosecution.
What are the offense?
Malad, offenses, Malad, 460. Malad, offenses under section 465, 468, 471, 420, 120B, IPC. Malad, according to the prosecution, Malad, complainant, Malad, who has an ex-serviceman. Malad, he granted the land in 1992, Malad, by the land tribunal of Vascote. Malad, in the 27 to 1992. Malad, thereafter, Malad, he also got a grant certificate, Sagwali Chit, in 1992. Malad, he never cultivated the land. He was going and seeing the land and coming back. He is residing at 35 to 40 kilometers from the said land.
Yes.
But in the meanwhile, Madar, in the year, Malad, 2024, Malad, he wanted to get a sanction of a loan from the SBI, State Bank of India. Malad, he verified the records. He came to know in the EC, the names of the persons are different in the EC. Malad, based on that, Malad, he filed a complaint on 17/4/2024, registered a case in crime number 115 of 2024, Malad, by Vascote police station. Malad, according to the prosecution, Malad, these A2 and A3 are owners of the property. Malad, they sold the said land to this A1, Malad, under the registered agreement deed at Vascote sub-register office for a consideration of rupees 72 lakhs. And that, Malad, out of 72 lakhs, Malad, he has received A2, A3 received 4 lakhs advance from A1. Malad, thereafter, Malad, after producing all the documents, Malad, he undertake to execute absolute sale deed. And position is with the A2 and A3. Malad, afterwards, Malad, I came to know this land was being sold to A6. Malad, this A2 and A3 for a consideration of rupees 2 crores and ad. Malad, after verifying the document, immediately, Malad, I went to the police station. On 17, Malad, I filed a complaint as per Malad, page number 45 to 53. Malad, on 12/3/2024, against Malad, A2 and A3, Malad, they also cheated me. Malad, I also produced Annexure K, page number 45. Malad, complaint to the DGP, IG, Superintendent of Police, Bangalore District Rural, and also Deputy Superintendent of Vascote Subdivision, and also police station. Malad, they did not initiate action against A2 and A3. Annexure K, Malad, page number 45. Malad, after filing this complaint, Malad, the police did not take initiative any action against A2 and A3. Malad, instead of that, Malad, thereafter, Malad, they filed a complaint against me. Malad, on 12/4/2024, as if, my lord, I have cheated this complainant and also colluding with, my lord, A2 to A5. My lord, A4 and A5 happens to be a panchas to the witnesses to the my document. I also produced the document, my lord, sale deed. Sale deed agreement of sale, my lord, page number 18.
No, you are the agreement holder or sale deed?
My lord, agreement holder, man. Again, registered agreement holder from A2 and A3. My lord, A2 and A3 also sold to A6. Actually, they cheated me, my lord. And I filed a complaint against A2 and A3. They did not initiate action against those A2 and A3. Waited for 1 month, 1 month, 2 days, then filed a case against me, my lord, because I am happens to be a, my lord, a local politicians against, my lord, therefore case has been registered against me.
Yes. What is-
My lordship, petitioner has created sale agreements in support of complainant property, my lordship. Investigation is still going on, my lordship. Interrogation is very much needed in this case, my lordship.
Now, you heard his saying, he has already filed a complaint against accused number 2 and 3 on 12/3/2024.
Yes, my lordship.
You are not denying that.
Because,
It
my
is
lordship,
only thereafter the present complaint was came to be filed.
but still investigation after the
Let him cooperate in.
not
Yes,
in
I am
this
ready.
stage, my lordship.
I am, in
Support
fact,
the
I am a
plea.
president of Cooperative Bank.
1 month earlier, he has filed the complaint.
Yes.
They have to secure documents, in my lordship.
Petitioner being accused number 1 is seeking grant of anticipatory bail as he is having apprehension of being arrested. It is stated that the informant, an ex-serviceman, logged the first information on 12/4/2024 against accused number 1 to 6, alleging that he is the owner of the land in question, as the same was in his favor by the land tribunal on 27, as per order dated 27/10/1992. He came to know that the names of different persons came to be entered in the encumbrance certificate when he verified the documentation. And thereafter, the complaint was came to be filed. Then the advocate for the petitioner has drawn my attention to where is the FIR registered by you?
My lord, page your lordship's annexed 8,
Page number,
page number 18, my lord.
page number?
बंद से तप्पा कर है.
What is the crime number? Which is the police station?
My lord, I also give a complaint to the DGP. My lord, page number 45, page number 45. I first, my lord, DGP and Inspector IG and Superintendent of Rural Police Station.
Police station again ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿದ್ದೀವಿ ಠಾಣಾ ಹೊಸಕೋಟೆ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಎಲ್ಲಿದೆ?
ಅದೇ page number 45, my lord. Last name, ಠಾಣಾ ಅಧಿಕಾರಿ ಹೊಸಕೋಟೆ police station ಕಚೇರಿ.
FIR was not registered?
No, my lord, they didn't issue only acknowledgement, but they did not register a case.
Can I tell you? The copy of the complaint dated 12/3/2024 produced as per Annexure K with the endorsement of the station house officer, Hoskote Police Station, Bengaluru District, whereunder he alleged, whereunder he filed the complaint against accused number 2 and 3 for having cheated him by selling the very same land in favor of accused number 6, even after executing the registered agreement for sale and receiving an amount of rupees 72 lakhs. You have already paid 72 lakhs?
My lord, I paid 4 lakhs, my lord. And
Yes,
I have not
4
been
lakhs.
put into position of the land. Till getting all the relevant documents, I undertake to execute absolute sale deed.
Stated that no FIR was registered, even though the police have received this complaint on 12/3/2024. It is thereafter on 12/4/2024, the present complaint was going to be filed. Considering all these facts and circumstances, I am of the opinion that the petitioner may be granted and is to be subject to conditions which will take care of so and so. Allowed subject to conditions.
Much of it.
2020. IA1 of 2024 is dismissed.
Four 39, sole accused. Arrested on 11/12/23. Victim girl is aged about 17 years. Studying at PUC.
Who is the complainant?
Father of the victim girl.
Father or mother?
Sorry, mother. It is a case of reverse love jihad. Lord, on 9/12/2023, the petitioner and the victim girl were going on a bike. Some persons, my lord, withstand obstructed them and assaulted the petitioner. And he was brutally assaulted and dumped into the drain.
So petitioner took the victim on the motorcycle.
Yes, ma'am. They were on motorcycle, going on a motorcycle.
Yes.
Some persons, my lord, are around 5 to 6 persons obstructed and my lord, assaulted him. He filed a complaint, my lord, on 19/12/2023 at about 19 hours.
Not 19, sir.
9/12/23 at
Yes.
about 19 hours for the offenses 307 and other offenses. Thereafter, this complaint is filed by the mother of the
Yes.
victim girl, saying that, my lord, they were the petitioner, my lord, and victim girl were in love, and they had a sexual into physical relationship, and the petitioner has committed sexual offenses twice.
Yes.
Now, my submission, my lord, is that both are in love. This complaint, my lord, is filed as a counterblast to the first complaint, saying that, my lord, committed sexual intercourse.
No, which is the counter complaint? Which is the first complaint?
First complaint, my lord, filed with the petitioner on page 55.
Page
55. Page 55.
It is filed by petitioner.
Yes, my lord, Srinivasa. Saying that, my lord, when the victim girl and himself were going on a bike, some persons came and assaulted him. Because, my lord, he is taking that particular committee girl on his bike. Different communities, petitioner and victim girl.
Complaint against whom?
Against the petitioner, ma'am. Sorry.
No, you
No, that
filed the
complaint
complaint.
against 4 persons, one Babu, Kadir, Pailwan, and others.
Yes, what do you say?
My lordship, in 164 statement, my lordship, in the second para, ಅವರ ಮನೆಯಲ್ಲಿ ಶ್ರೀನಿವಾಸನ ಅಮ್ಮ ಇದ್ದರು. ಅವರು ನನಗೆ ಮನೆ ತೋರಿಸಿದರು. ನಂತರ ಕುಳಿತುಕೋ, ಜ್ಯೂಸ್ ಕುಡಿ ಅಂತ ಜಬರ್ದಸ್ತಿ ಮಾಡಿದರು. ನಾನು ಜ್ಯೂಸ್ ಕುಡಿದೆ. ಜ್ಯೂಸ್ ಕುಡಿದ ನಂತರ ನನಗೆ ಎಚ್ಚರ ಇರಲಿಲ್ಲ. ಎಚ್ಚರ ಬಂದ ನಂತರ ನಾನು ನಮ್ಮ ಮನೆಗೆ ಹೋಗುತ್ತಿರುವಾಗ ಮೆಟ್ಟಿಲು ಹತ್ತಿರ ಶ್ರೀನಿವಾಸ್ ನನಗೆ ಎದುರಾದ. ಅವನು ನನಗೆ, ನಾನು ನಿನ್ನ ಫೋಟೋ ತೆಗೆದಿದ್ದೇನೆ, ನಾನು ಕರೆದಾಗಲೆಲ್ಲ ಬರಬೇಕು, ಇಲ್ಲದಿದ್ದರೆ ನಿನ್ನ ಫೋಟೋ ವೈರಲ್ ಮಾಡುತ್ತೇನೆ ಅಂತ ಹೆದರಿಸಿದ. ನಾನು ಹೆದರಿಕೊಂಡು ಮನೆಗೆ ಹೋದ. Even in next para also she has mentioned, my lordship, she has supported the case, my lordship. Even kindly see the medical report, my lordship. Hymen, it's a ruptured.
Yes.
As per medical examination.
What is the age of the victim?
17 and a half.
17.
They were in love. I have produced all details also.
Charge sheet is filed.
Yes, my lords. And the medical report, my lord, saying that there is rupture.
Petitioner being the sole accused is before this court seeking grant of bail. When you are arrested,
He was arrested on 11/12/23.
apprehended on 11/12/2023. Since then, he is in judicial custody. The mother of the victim lodged the first information, making allegations as stated above. Because the said complaint came to be lodged on 9/12/2023 at 2:30. 19 hours. Right there. On 9/12/2023 and registered in crime number 160 of 2023. Where is the FIR registered on your complaint?
Page 55.
The first FIR is 376.
Page 55.
Whereas the petitioner has produced the FIR in crime number 132 of 2023, registered on the basis of the first information lodged by the petitioner against accused number 1 to 4. In the first information lodged by the petitioner, there is a reference to the victim whom he had taken on the motorcycle for the purpose of giving the drop. It is thereafter the present complaint came to be filed. By the mother of the victim girl. Investigation is completed and the charge sheet is also filed. Considering these facts and circumstances, I am of the opinion that the petitioner may be enlarged on bail subject to conditions which will take care of so and so. Allowed subject to conditions.
Yes.
Police report. Either. Yes, police.
Notice, sir, my lordship.
Served.
Sir, next day.
HCGP submits that the notice on respondent number 2 is already served. Yes.
I have to
4:38.
secure records, my lordship, in this week.
HCGP prays for time to secure records.
Friday.
Yes, next week.
Any date maybe?
Date for next.
Four 39, my lord, sole accused. Section 8 and 12 of the POCSO Act.
My lordship, in this also I have to get records, my lordship.
CGP prays for time. Next date.
Date maybe.
Date will be given, sir.
Please.
Please take the date. Next.
Please. Petition. I have to. 38 petition. my lord.
Yes.
Lord, accused number 1 and accused number 4.
In all, how many accused are there?
Accused number 4 accused persons are there. Offense under section 306.
For 2 and 3.
Well, 2 accused number 2 and 4. 2 and 4. my lord, during the pendency of this petition, they have arrested. 1 and 3 have been arrested.
1 and 3.
Have been arrested.
And I have requested before this Honorable Court to withdraw this petition so far as the 3 and 4 is concerned. 2 and 4 is concerned. Petition is withdrawn.
Be certain. Who are arrested, accused number 1 and 3.
1 and 3 is arrested.
Now the petitioners are accused number
Accused number 1 and 3.
1 is already
2 and
arrested,
4.
sir.
That's what 1 and 3 is arrested.
Ah.
And 3 and 2 and 4 is before this.
Yes,
2 and 4 is before this Honorable Court for anticipatory.
yes.
Allegation is, my lord, the deceased husband has filed this complaint on 1/5/2024, alleging that they are the tenants under the accused number 1,
306.
306. In Kolar, they are, my lord, they are residing in Kolar.
Now, who is the complainant?
Complaint, the deceased husband.
No.
Bala Govinda, deceased husband.
What is the allegation?
Allegation is, my lord, the Bala Govinda, that is the complainant, and the, my lord, accused persons here are the tenant and owner. Accused are the owners, complainant are the tenant.
Yes.
And both of them are friends.
Yes.
And both of them are, my lord, contractors. Accused number 1 and the complainant. Since, my lord, they were taken the house on rent on 2020. When they taken on the rent, not after some years, that is on the April, the wife of the first accused, that is the accused number 2, has requested the tenant, that is the complainant, to vacate the house because they required for the brother of the second accused. There, accordingly, they vacated the house on 26/4/2024. House was vacated, and rent was some balance rent was there, and that is a different aspect. But they vacated the house on 26/4/2024. Now there on 29/4/2029, there were certain materials in the house. So therefore, the deceased came to collect the materials. By that time, my lord, the accused number 3, has abused the deceased, saying that you have made certain complaints against me and my brother. Therefore, we are going to kill you. And they have hold the yes, and they are going to kill you. But that was the allegation they have made.
That was on?
That was on 29/4/2024 by about 3:30 p.m. Then they went off. Then the same has not informed to the complainant, that to husband. They went back. Well, she was since she wanted to come to near to Devnal, their matrimonial home, Chinnaganahallige. She came along with the husband to Chinnaganahalli. Then they went back to since she was not feeling well. She was taken a treatment. The husband, the complainant, has taken her and the son for treatment to Vascota. They have taken the treatment. Then on 30th, when they were there in the near Chinnaganahalli, this is 50 kilometers to Kolar to Chinnaganahalli. This is in Devnalli. She committed suicide. When she was in Devnalli, in the night, this story has been narrated to the husband. I was not happy with them. They said, therefore, this is what has happened in the rented house in the 29th. I'm fed up. This was explained to her husband. And the night, she went back house. Back she committed suicide. That found in the next day. That is on 1/5/2005.
How she committed?
She went to the back. Said well. She went there and committed suicide. And they were searching. They could not able to find. In the next day, somebody third person was informed. Then they found that the dead body was found in the well. So this is the story in the complaint. But this unfortunate thing, they are in Kolar. rented in, they have taken the rent and Kolar. Both of them are friends. And she was, according to the complaint, she was working as maid servant. Maid servant. And there is no such kind of incident has taken place. But the only thing is, my lord, in between them, there was a balance of rent. And they requested them to return that, since they did not pay rent for 10 months, they have asked. Because of that reason, my lord, they created this story because there is some different, she is suffering from, my lord, stomach ache. They themselves are admitted that, my lord.
Yes, what do you say?
1 and 3 are arrested, my lord.
Hmm.
And 2 and 4 are same allegation against the.
What is the allegation against 2 and 4?
2 and 4 is,
They are not the owner of the house.
they are the owner. 1 and 2 is the father and mother, my lord. 2 and 4 are their sons.
Whole family is robbed in.
Accused number 1 is the father.
1 is the father, 2 is the mother. 3 and 4 are the sons.
Sons. Our students, my lord, they are studying. Rent ke liye the whole family has doubled into it.
ಏನಾಗಿದೆ ತಗೊಳ್ಳಿ. Petitioners. Petitioner numbers 2 and 4. Being accused number 2 and 4 are seeking grant of anticipatory bail. Petition number 1 and 3, being accused number 1 and 3 are already apprehended, and the petition filed by them is dismissed with a order dated so and so. The informant is the husband of the deceased. They stated that the informant along with his family was staying in the house owned by accused number 1 as tenant. Few days back, they have vacated the house. On 29/4/2024. Deceased came to collect the materials for the purpose of shifting. At that time, the accused abused her. On 30/4/2024, the deceased was taken to the hospital by the informant as she was complaining of ill health. Thereafter, both of them went to a temple and returned to Chennai. In the night, the deceased is said to have narrated all the incident to the informant, and on the same day, she committed suicide by jumping into a water pond. Admittedly, accused number 1 and 3 are already arrested. The nature of allegation do not require accused number 2 and 4 custodial intervention. Reasonable conditions may be imposed. Allowed subject to conditions.
Yeah, for petition in this case, my lords. Petition under 438 of CRPC, my lords. That's the present petition as accused number 1 and 2, my lords. In total, there are 8 accused, my lords.
Petitioners in 4499.
4499 is petition number, accused number 2, my lords.
And 4505.
Is accused number 1 as per the complaint, my lords. My name is not shown in the FIR, my lords. As per the complaint, I'm accused number 1 in 4505 and 4499, I'm accused number 2, my lords, as per the complaint. My lords, the
Charge sheet is already filed.
No, my lords. I would like to take my lords to the.
Offense alleged.
Lords, alleged offences are punishable under section 67A of Information Technology Act and 171G of IPC, my lords. I'd like to take my lords to the in page number 8, which is the complaint, my lords. ಹಾಸನ ಜೆಡಿಎಸ್ ಹಾಗೂ ಬಿಜೆಪಿ ಮೈತ್ರದ ಪಕ್ಷದ ವತಿಯಿಂದ ಲೋಕಸಭಾ ಚುನಾವಣೆಗೆ ಸ್ಪರ್ಧಿಸಿರುವ ಅಭ್ಯರ್ಥಿ ಭಾವಚಿತ್ರವನ್ನು ಮಾರ್ಫ್ ಮಾಡಿ ಬಳಸಿಕೊಂಡು ಅಶ್ಲೀಲ ಚಿತ್ರಗಳು ಹಾಗೂ ವಿಡಿಯೋಗಳನ್ನು ತಯಾರಿಸಿಕೊಂಡು ಹಾಸನ ಲೋಕಸಭಾ ಕ್ಷೇತ್ರಾದ್ಯಂತ ಮನೆ ಮನೆಗೆ ಪೆನ್ ಡ್ರೈವ್, ಸಿಡಿಗಳು ಹಾಗೂ ಮೊಬೈಲ್ ಮತ್ತು ವಾಟ್ಸಪ್ ಮೂಲಕ ತಲುಪಿಸಿರುವ ವ್ಯಕ್ತಿಗಳ ಮೇಲೆ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ದಾಖಲಿಸಿ ಎಫ್ಐಆರ್ ದಾಖಲು ಮಾಡಿ ಸದರಿಯವರನ್ನು ಕೂಡಲೇ ಬಂಧಿಸಿ ಕಾನೂನು ಕ್ರಮ ಕೈಗೊಳ್ಳುವ ಬಗ್ಗೆ. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಮೈ ಲಾರ್ಡ್ಸ್, ಪೇಜ್ ನಂಬರ್ 9. ಹಾಸನ ಲೋಕಸಭಾ ಕ್ಷೇತ್ರದ ಕಾಂಗ್ರೆಸ್ ಅಭ್ಯರ್ಥಿಯಾದ ಶ್ರೀ ಶ್ರೇಯಸ್ ಎಂ ಪಾಟೀಲ್ ಹಾಗೂ ಕೆಲವು ಕಾಂಗ್ರೆಸ್ ಕಾರ್ಯಕರ್ತರೊಂದಿಗೆ ದಿನಾಂಕ 26/4/2024 ಲೋಕಸಭಾ ಕ್ಷೇತ್ರಕ್ಕೆ ಚುನಾವಣೆ ಇರುವುದರಿಂದ ನಮ್ಮ ಲೋಕಸಭಾ ಅಭ್ಯರ್ಥಿ ವಿರುದ್ಧ ದಿನಾಂಕ 21/4/2024 ಸಂಜೆ 6:30ರಿಂದ ಹಾಸನ ಲೋಕಸಭಾ ಕ್ಷೇತ್ರಾದ್ಯಂತ ಮೇಲ್ಕೊಂಡ ನಮ್ಮ ಅಭ್ಯರ್ಥಿಗಳವರ ಭಾವಚಿತ್ರಗಳನ್ನು ಮಾರ್ಫ್ ಮಾಡಿ ಅಶ್ಲೀಲ ಭಾವಚಿತ್ರಗಳನ್ನು ಮತ್ತು ವಿಡಿಯೋಗಳನ್ನು ತಯಾರಿಸಿಕೊಂಡು ಹಾಸನ ಲೋಕಸಭಾ ಕ್ಷೇತ್ರದ ವ್ಯಾಪ್ತಿಯಲ್ಲಿರುವ ಮನೆ ಮನೆಗೆ ಹೋಗಿ ಮಾರ್ಕ್ ಮಾಡಿರುವ ಅಶ್ಲೀಲ ಭಾವಚಿತ್ರಗಳು ಅಥವಾ ವಿಡಿಯೋಗಳನ್ನು ಮತದಾರರಿಗೆ ತೋರಿಸಿ ಹಾಗೂ ವಾಟ್ಸಪ್ ಮೂಲಕ ಅಥವಾ ಮೊಬೈಲ್ಗಳಲ್ಲಿ ತೋರಿಸಿ ಜನರ ದಿಕ್ಕು ತಪ್ಪಿಸಿ ನಮ್ಮ ಅಭ್ಯರ್ಥಿಗೆ ಮತದಾನ ಮಾಡದಂತೆ ಪ್ರಚೋದಿಸುತ್ತಿದ್ದು ಹಾಗೂ ಈ ಚುನಾವಣೆಯಲ್ಲಿ ನ್ಯಾಯಯುತ ಮತದಾನ ಆಗುವುದನ್ನು ತಪ್ಪಿಸುವ ಸಲುವಾಗಿ ಈ ದುಷ್ಕೃತ್ಯವನ್ನು ಎಸಗುತ್ತಿದ್ದು ಈ ಮೇಲ್ಕೊಂಡವರ ಮೇಲೆ ಎಫ್ಐಆರ್ ಅಥವಾ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ದಾಖಲಿಸಿ. My lords, the date of incident is on 21/4/2024, my lords. Date of complaint is on 23/4/2024, my lords. There is a delay of 2 days in filing of the complaint, my lords. My lords, the complaint here is in one MG Purnachandra Tejasvi claiming to be a JDS and BJP party's election agent, my lords. My lord, the complaint here has no locus standi, has not been appointed as the election agent as so far on the date of the complaint, my lord. That is on 23/4/2024, my lords.
Yes.
And the code of conduct was prevailed, my lords, but not intimated the same to the election commission or the squad about the election related offences, my lords. There is no reference with regard to the pen drive in the complaint, my lords. In the complaint, they only stated that the copy of the post posted in the Facebook account of one Navin Goda, who has been arrested, my lords, who is shown in the FIR as accused number 1, my lords.
Who
In
is
complaint
arrested?
in page number 9, it says that Lagatu Facebook Sri Navin Goda
Accused number 1 is arrested.
accused number 1, sir.
But
All the
according
accused have
to
been
you-
arrested, my lord, except this accused number 1 and 2, all the accused have been arrested, my lord.
No, you are saying that petitioner in 4505 is accused number 1.
Accused number 1, my lord, as per the complaint, my lord, but they have shown accused number 1 in FIR in complaint in the FIR.
Now has been accused number 2.
It's now right, has been accused.
Who is accused number 2?
Accused number 2 is Karthik. He is a petitioner in 4505 of 24.
And who is petitioner in 4499?
He is accused number 3, my lord, Putraj.
Accused number 1 is arrested.
Accused number 1 is arrested.
What about others? According
Accused
to
number
you, there are
5 and
8
accused
accused.
number 6 also arrested, my lord. Accused number 8 is also arrested.
What about 4 and 5?
4 is absconding, my lord. 5 is arrested.
5 is arrested.
Yes, my lord.
4 is absconding.
4 is absconding.
What about 7?
He's not been arrested yet.
Hmm.
Lord, see in the page, no?
What do you say?
Lord, this is the case where
ಆಯ್ತಲ್ಲ ಅದೆಲ್ಲ ಈಗ much water has flown.
no, it's not much, my lord. There are many more water has to flown. What happened in this case is only tip of the iceberg. The incident, my lord, though the complaint says it is a mock video, it is not the mock video, it is the video of many women identity have been exposed, and then those moments are put to misery. Second issue, my lord, the investigation so far also reveals that the action of the petitioner does not end in distributing the pen drive. Action of the petition, my lord, is also goes to a further extent that they have contacted some of the victims, extracted money from them. And the original pen drive, which is supposed to have been handed over by accused number 2 to accused number 3, is yet to be recovered, which is the main source for entire investigation, my lord, in this case. Though it on face of it, my lord, appears to be very, as my learned friend put it, appears to be simple, my lord. It is a case where people have lost livelihood and displaced them from their own houses. So the custodial interrogation, my lord, is the element to understand the extent of conspiracy which these people have hatched into, and the possibility of victims have been threatened and then
extracted money from them has to be investigated in this case. Therefore, especially, my lord, the petitioner, petition number 3, my lord, is convicted in 302. And he is on,
Accused number 3.
accused number 3, my lord, is convicted in 302. And is on bail by mercy of this honorable court in an appeal, suspension of sentence. After, my lord, committing this heinous crime, my lord, then he is continued to this crime. And he is the main person, my lord, who is used to extract money from innocent victims. And this may not be a case, my lord, where your lordship can exercise the discretionary power under 438.
My lord, alleged offense only 67 of IT Act, my lord, only punishable for 5 years, my lord, trial by magistrate, my lords.
Yes.
And with reference to the pen drive, my lords, they are not in the complaint. I'll take my lords to the page number 9, my lord, the complaint, my lords. Lagatu Facebook Sri Naveen Goda ಎಂಬುವರ ಖಾತೆಯಲ್ಲಿ post ಮಾಡಿರೋ ಪ್ರತಿ only the complaint in Lagat ಅವ್ರು ಏನೇ ಕೊಟ್ಟಿರೋದು ಇದು only this Facebook post they have given, my lords. Naveen Goda is the accused number 1, my lords. He has been arrested, my lords. The complaints also fall short of explanation with respect to how we obtained the possession of the pen drive and other materials also, my lord. Not been explained in the complaint, my lords.
That will investigate, my lord, that how he have obtained and what manner. And it is not limited to Facebook, I believe, my lord,
The only basis of the copy of the post book.
Petitioner's common order. Petitioner in criminal petition number 4499 of 2024 is accused number 3. And the 4505 is 4505 of 2024 is accused number 2. They are seeking grant of anticipatory on the apprehension of being arrested. The informant has filed the complaint against accused number 128, making allegations that they have conspired together and in view of the Lok Sabha election to influence the voters and to defame, influence the voter and to blackmail the victims for the purpose of extracting their amount, distributed the pen drive and shared the marked photos and videos through the social media account of accused number 1. It is stated that these petitioners, being accused number 2 and 3, were in possession of the original pen drive, which is required to be recovered by subjecting them to interrogation. And then the additional SPP submission that by using this marked photos and videos, the accused have extracted money from the victim, which made them to leave their house, which resulted in losing their livelihood. The effect of the acts of the accused is said to be very serious. When such serious allegations are made, and it is specifically contended that the petitioners are required for custodial interrogation for the purpose of recovering the material objects, I am of opinion that the petitioners are not entitled for grant of anticipatory bail. Dismissed.
Great.
Lord, 439 petition.
Yes.
Lord, statute for 307 of IPC.
Uh.
Sole accused.
When arrested?
Well, Lord, arrested on 2/7 to the 2022.
7?
2/7/22.
22.
Please, Lord.
Charge sheet is filed.
Charge sheet is filed. Lord, on the alleged date of incident, my lord, the complaint has come to his.
This is the stage before the trial court.
Lord, I have to ascertain, my lord.
Huh?
I have to ascertain, my lord.
This is the first petition filed
First
by-
petition. He's a labor class, my lord. I couldn't come before this court in time.
Come to page 35. What is
Yes,
the
my lord.
allegation?
Allegation is that, my lord, the complainant was working in another a real estate, my lord, coffee estate. He has come to that to his parents, my lord, to see his parents on that particular day, my lord, on the in the afternoon. My lord, in the evening, my lord, there was a quarrel between accused number 1 and his wife regarding she was having an illicit relationship with the complainant. Then, my lord, the complainant has went to the house of the accused number 1 and tried to pacify the quarrel. In that quarrel, my lord, accused number went to his kitchen, my lord, and brought the katti and assaulted the complainant. Due to that, my lord, there was an injury, my lord, on this hand. They have produced a wound certificate which is.
It had occurred where?
Sorry, my lord.
Incident had occurred.
Accused number 1's house itself.
So complainant had came to the house of the.
Accused number 1. There was a quarrel between accused number 1 and his wife. That she was having a relationship with his complainant. That's why he has come to the village on that day. On that aspect, my lord, case was prosecution case was. I produced a wound certificate, my lord, which is in page 76.
Assault with a knife.
Knife, katti.
Knife or katti?
Katti, my lord, not knife. They have used the word katti. I produced the wound certificate, my lord. There is only one injury. That injury is grievous in nature.
Where is it?
76.
Page number?
76, my lord. The wound certificate also, they have not mentioned who has assaulted. Only one injury, my lord, which is in grievous in nature, which has been injury to the hand. No other injuries, only single injury. Above mentioned injuries, grievous in nature.
Yes.
Lord, he has suffered, my lord, permanent disfigurement of my lord hand, wrist, my lord. He has
Only
lost
one-
my lord hand.
Only one injury.
One injury, but he has lost his hand, my lord. That allegation is, my lord, kindly see charge sheet, my lord. ಹಸ್ತವು ಮಣಿಗಂಟಿನಿಂದ ಪ್ರತ್ಯೇಕವಾಗಿ ತುಂಡಾಗಿದ್ದು ಈ ಘಟನೆಯಿಂದ ಸಾಕ್ಷಿ ಒಂದರವರು ತನ್ನ ಜೀವನ ಪರ್ಯಂತ ಹಸ್ತ ಇಲ್ಲದೆ ಜೀವನ ನಡೆಸುವ ಸಂಭವ ಉಂಟಾಗಿರುವುದು ಪ್ರಕರಣದ ಇವರ ತನಿಖೆಯಿಂದ ತಿಳಿದು ಬಂದಿರುತ್ತೆ.
The hands were broken, my lord. For 307.
For my lord, he cannot, my lord.
26.
For there is a serious allegation, my lord.
ಎಲ್ಲಿದೆ ಅದು ಹಸ್ತ ಇಲ್ಲದೆ? ಇಲ್ಲೇ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ.
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ.
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ. ಪೇಜ್ 35 ಲಾಸ್ಟ್ ಲೈನ್ ಅಲ್ಲಿ. Therefore, my lord, considering the seriousness of the offense, my lord.
Of course, it is serious, but the incident had occurred in the house of accused number 1.
Yes, my lord.
Sudden quarrel.
Complainant had gone there.
Yes. However, my lord.
What business he was having to go
Yes.
and interfere in the quarrel that was taken place between the husband and wife. I covered. Petitioner being the sole accused is seeking grant of bail. Was apprehended on 2/7/2024. The injured himself is the complainant.
Yes, yes.
The injured lodged the first information, making specific allegations against the petitioner. That when he tried to intervene in the quarrel between accused number 1 and his wife, accused number 1 brought a chopper and assaulted him, as a result of which his right or left wrist suspect. The wound certificate produced by the learned counsel for the petitioner is that there was a traumatic disarticulation of the hand near the wrist, which is grievous in nature. The allegations is of serious nature, but the fact remains that the investigation is completed and charge sheet is filed. The victim has already been discharged from the hospital. The trial in the matter may take long period of time. And detention of the petitioner will be during that period. Known to so and so. It is not the contention of the prosecution that the petitioner is having any criminal anticipation. It is pertinent to note that the incident had occurred in the house of accused number 1, where the complainant had. When the complainant had gone there. Considering all these facts and circumstances, allowed and then subject to conditions which will take their action. Allowed subject to conditions.
Grateful.
What's that in application of lordship? Have filed a memo, your lordship, dispense the service of notice to the, so de facto complaint, your lordship.
Maybe tomorrow that may be the reason for cancellation.
At our risk.
What are the offense alleged?
Offense, your lordship, that is,
326.
please, your lordship,
In 326.
326,
Huh.
308, 506.
Third is the complainant.
Injured is not the complaint, your lordship.
Then
The conductor of the bus was the complainant. The case of the complaint, your lordship, that while the bus was traveling,
what do you say regarding his prayer for dispensation? Alari, dispensation from issuance of notice to respondent number 2. Heard learned counsel for the petitioner and learned HCP. And the memo filed by the learned counsel for the petitioner. In dispensation of notice to respondent number 2. Learned HCP has no objection to allow the petition as a respondent number 2 is the informant and not the victim. Hence, issuance of notice to respondent number 2 is dispensed with. Yes.
lordship. The FIR incident was taken on 22/12/2022. FIR was registered on 23/12/2000.
Petitioner is accused number. Sole accused.
Sole accused. your lordship.
When he was arrested,
He is arrested on 23/12/2024, your lordship. 3/12/24. Immediately on the next date.
23/12.
23, your lordship, sorry. And charge sheet filed on 5/3/24, your lordship.
Where is the charge sheet?
Charge sheet, your lordship, and get at page
Page 35.
29 onwards, your lordship.
Come to page 35.
Yes, your lordship. ದಿನಾಂಕ 22/12 ರಾತ್ರಿ 8:40 ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ವ್ಯಾಪ್ತಿಗೆ ಬರುವ ಮದ್ದೂರು ಪೊಲೀಸ್ ಠಾಣಾ ಸರಹದ್ದಿನ ಮದ್ದೂರು ಟೌನ್ ಈದ್ಗಾ ಮೈದಾನದ ಮುಂದೆ ಆದಂತೆ ಹಾದು ಹೋಗಿರುವ ಮದ್ದೂರು ಮಳವಳ್ಳಿ ರಾಜ ರಸ್ತೆ ಹೆದ್ದಾರಿಯಲ್ಲಿ ಸಾಕ್ಷಿ 2 ಜಯಕುಮಾರ್ ರವರು, ದಟ್ ಇಸ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ವಿಕ್ಟಿಮ್, KF ನಂಬರ್ ಬಸ್ಸಿನಲ್ಲಿ ಪಕ್ಕದಲ್ಲಿ ಕುಳಿತುಕೊಂಡು ಕೊಳ್ಳೇಗಾಲದ ಕಡೆಗೆ ಪ್ರಯಾಣಿಸುತ್ತಿದ್ದಾಗ ಅದೇ ಸಮಯದಲ್ಲಿ ಈದ್ಗಾ ಮೈದಾನ ಮುಂದೆ ನಿಂತಿದ್ದ ದೋಷಾರೋಪಣಾ ಪತ್ರ ಕಾಲಂ 12 ಕಂಡ ಆರೋಪಿ ನಾಗ ಅಲಿಯಸ್ ಹಂದಿನಾಗ ಹೋಗುತ್ತಿದ್ದ ಬಸ್ಸನ್ನು ಕಂಡು ಸೋ ಜೋರಾಗಿ ಅರಚಿಕೊಂಡು ಫುಟ್ಪಾತ್ಗೆ ಹಾಕಿರುವ ಸಿಮೆಂಟ್ ಬ್ರಿಕ್ ಕಲ್ಲನ್ನು ಎತ್ತಿಕೊಂಡು ಏಕಾಏಕಿ ಸಹ2ರವರಿಗೆ ಕುಳಿತಿದ್ದ ಕಿಟಿಗೆ ಹೊಡೆದು ಸಹ2 ತಲೆಗೆ ಹೊಡೆದಿದ್ದ ಪರಿಣಾಮ 2ರವರ ತಲೆಯಲ್ಲಿ ತೀವ್ರ ಸ್ವರೂಪದ ರಕ್ತಗಾಯವಾಗಿದ್ದು ಆರೋಪಿ ಬಸ್ಸಿನಲ್ಲಿ ಪ್ರಯಾಣಿಸುತ್ತಿದ್ದ ಜನರಿಗೆ ಸಿಮೆಂಟ್ ಬ್ರಿಕ್ಸ್ ಕಲಿಸಿ ಹೊಡೆದ ಜೀವ ಅಪಾಯ ಸಂಭವಿಸಿದೆ ತಿಳುವಳಿಕೆ. ದಿಸ್ ಇಸ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್. Now the lordship complaint, your lordship, kindly report. Complaint, your lordship. That's page 14. Page 14, your lordship, complaint. ನಾನು ಕೊಳ್ಳೇಗಾಲ KSRTC ಡಿಪೋದಲ್ಲಿ ಕಂಡಕ್ಟರ್ ಆಗಿ ಕೆಲಸ ಮಾಡುತ್ತಿರುತ್ತೇನೆ. ದಿನಾಂಕ 22/12/21 ನನಗೆ ಮತ್ತು ಡ್ರೈವರ್ ಆದ ಸುಂದರ್ 54 ಕೊಳ್ಳೇಗಾಲ ಬೆಂಗಳೂರಿಗೆ ರೂಟ್ 2AB ನೇಮಕವಾಗಿದ್ದು. ಅದರಂತೆ ನಾವು KA so and so ಬಸ್ಸಿನಲ್ಲಿ ಬೆಂಗಳೂರಿಗೆ ಹೋಗಿ ವಾಪಸ್ ಪ್ರಯಾಣಿಕರನ್ನು ಕರೆದುಕೊಂಡು ಕೊಳ್ಳೇಗಾಲಕ್ಕೆ ಬರಲು ಮದ್ದೂರಿಗೆ ಬಂದು ರಾತ್ರಿ 24 ಗಂಟೆಯಲ್ಲಿ ಮದ್ದೂರು ಕೊಳ್ಳೇಗಾಲ ರಸ್ತೆಯಲ್ಲಿ ಮುಸ್ಲಿಂ ಈದ್ಗಾ ಮೈದಾನದ ನೇರ ರಸ್ತೆಯಲ್ಲಿ ಹೋಗುವಾಗ ಅದೇ ಸಮಯದಲ್ಲಿ ರಸ್ತೆ ಪಕ್ಕದಲ್ಲಿ ಫುಟ್ಪಾತ್ನಲ್ಲಿ ನಿಂತಿದ್ದ ಯಾರೋ ಒಬ್ಬ ಅಸಾಮಿಯು ಹೋಗುತ್ತಿದ್ದ ನಮ್ಮ ಬಸ್ಸನ್ನು ಕಂಡುಕೊಳ್ಳಲು ಮಕ್ಕಳೇ ಜೋರಾಗಿ ಅರಚುತ್ತಕೊಂಡು ಫುಟ್ಪಾತ್ಗೆ ಹಾಕಿದ್ದ ಸಿಮೆಂಟ್ ಬ್ರಿಕ್ಸ್ ಎತ್ತಿಕೊಂಡು ಏಕಾಏಕಿ ನಮ್ಮ ಬಸ್ಸಿನ ಕಿಟಕಿಯ ಪಕ್ಕದಲ್ಲಿ ಕುಳಿತಿದ್ದ ಅಸಾಮಿಯನ್ನು ಗುರಿಯಾಗಿಸಿಕೊಂಡು ಹೊಡೆದನು. ಹೊಡೆದರ ಬಸಕ್ಕೆ ಬ್ರಿಕ್ಸ್ ಬಸ್ಸಿನ ಕಿಟಕಿ ಪಕ್ಕದ ಕಂಬಿಗೆ ಹೊಡೆದು ಸೀಟಿನಲ್ಲಿ ಕುಳಿತಿದ್ದ ಯಾಲಹುಂಡಿ ಗ್ರಾಮದ ಜಯಕುಮಾರ ಬಿನ್ ಪುಟ್ಟಸ್ವಾಮಿ ಎಂಬುವರ ತಲೆಗೆ ಹೊಡೆಯಿತು. ಆಗ ಜಯಕುಮಾರ್ ಅವರ ತಲೆಗೆ ತೀವ್ರವಾದ ಮಾರಣಾಂತಿಕ ಗಾಯವಾಯಿತು. ಆಗ ಜಯಕುಮಾರ್ ಅವರು ಪ್ರಜ್ಞೆ ತಪ್ಪಿದರು. ಸದರಿ ಬ್ರಿಕ್ಸ್ನ ಏಟು ನೇರವಾಗಿ ಜಯಕುಮಾರ್ ಅವರಿಗೆ ಬಿದ್ದರು. ಸರಿದರು ಸ್ಥಳದಲ್ಲಿ ಸತ್ತು ಹೋಗುತ್ತಿದ್ದರು. ನಮ್ಮ ಡ್ರೈವರ್ ಬಸ್ಸಿನ
Where is the wound certificate?
wound certificate, Your Lordship, I have produced. I have not produced. Only one wound, Your Lordship, Your Lordship. Now, Your Lordship, that the whole complaint, Your Lordship, they states here, from Maddur hospital is taken to Mandya. From Mandya he was taken to Nimans. There is no material to show that Your Lordship was treated in Nimans hospital. One wound, Your Lordship, it is left frontal bone depressed, committed fracture with impingement into left frontal.
Yes.
Your Lordship, as per the charge sheet, Your Lordship, the complaint, Your Lordship, he was taken treatment at Nimans. But as per the charge sheet, Your Lordship, nothing on material to show that he was taken treatment at Nimans.
Yes. Now, what is the stage? Where, now whether it is committed, ಏನಾಗಿದೆ?
Stage,
Stage ಏನಿದೆ?
stage, I have not.
Yes, that is.
He's having 10 cases, madam. The similar offense also referring as well, madam. Crime number 452 of 2018, madam. The sections 143, 341, 149.
How many cases in all?
10 cases.
Hmm.
The similar kind of offense also there, crime number 452 of 18, madam, 2018.
Hmm.
In that, madam, Karnataka topic of damage act also, it is still pending, madam.
Yes.
Meeting is similar offense.
Hmm.
Lordship. Now, Your Lordship, the prosecution case, Your Lordship, it's the stone, Your Lordship. I refer to Your Lordship, the Mazar, Your Lordship, drawn.
ಆಯ್ತು ಅದೆಲ್ಲ that will be considered by the trial court.
Lordship, now.
Strong prima facie materials are placed before the court, and moreover, you are having a very bad
Lordship, that
criminal
is because,
antecedents.
no, one case is there, Your Lordship, 10 cases there. How
10
many cases it was
10
acquitted?
cases.
Out of which case, how many cases you was
You
acquitted?
have to find out from your client. You cannot depend upon her say. Either you should say no such case, or you should admit.
No, maybe there's one or two cases, Your Lordship,
10
but
cases she is saying. No. Not entire. Yes.
Lordship,
No,
then
ಅಲ್ಲೇ ಇರ್ಲಿ.
next week,
Society will be very safe.
please, Your Lordship.
ಏನು ಬೇಡ ಸುಮ್ಮನೆ ತಗೊಳ್ಳಿ. Petitioner being the sole accused is before this court sitting time of bail. Inspector of the KSRTC bus lodged the first information.
Pending of this similar cases, Your Lordship, not the ground to deny the.
Stating that the accused has hurled cement brick towards the bus which hit the bus first. Thereafter hit the passenger, one of the passengers who sustained head injury. Head injury. Immediately he was shifted to the hospital. The wound certificate issued by the government hospital, General Hospital, Maduru. This was his birth. The injured sustained injury as a result of assault. That is, the nature of injury is a cut lacerated bone or front parietal bone with fracture, which is grievous in nature. After investigation, charge sheet is filed, which makes out strong prima facie materials against the petitioner. It appears that the petitioner, without any provocation, hurled cement brick towards the victim with an intention to cause death. 308 of and caused the grievous injuries. The charge sheet is already filed. Next paragraph. It is pertinent to note that the Leonard SGP has made a specific submission that petitioner is a habitual offender, as he is having criminal antecedents for having involved in as many as 10 cases, few of which are similar in nature. The same is not denied by the Leonard counsel for the petitioner. Considering all these facts and circumstances, I am of opinion that the petitioner is not entitled for dismissed.
Other than wound certificate, Your Lordship, there is no material to show that he was admitted in the Nimans or the.
ನಿಮಾನ್ಸ್ ಬೇಡ ಸರ್, ಅಲ್ಲೇ ಇದೆ. ಸ್ಕಲ್ ಫ್ರಾಕ್ಚರ್ ಆಗಿದೆ ಹೊಡೆದು. Even according to the wound certificate.
No, but for that taking treatment, yes, there is no material furnished by the.
ಫ್ರಾಕ್ಚರ್ ಆಗಿದೆ ಅಂತಂದ್ರೆ ಇನ್ನೇನು ಹೇಳಿ? ಫ್ರಂಟಲ್ ಬೋನ್ ಫ್ರಾಕ್ಚರ್ ಆಗಿದೆ. ಎಸ್.
My lord, interim bail is granted. I pray for an adjournment in this case. A senior is held up in other court, my lord.
No.
Kindly pass over, my lord.
Pass over. Non-compliance. For review of judgment. How IA is maintainable. Okay. Learned counsel for the appellant is absent, no representation. Prima facie, the application is not maintainable. For review of the judgment. Judgment dated 18/5/2023. No reason to adjourn the matter, however, to offer final opportunity list 1 or 2 days between. Yes. List number 2.
The petition, my lord. Petition for 39 months. For the offense of 306 and 34 of
You
it.
have to comply with the office objection.
Yes, my lord. My lord, it is a defect by the respondent, my lord. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ in FIR, my lord, petition is. I put the office note, my lord.
Accused Swami, the same time member has filed. ಇನ್ನೊಂದು petition ಇದೆಯಾ? ಏನು office objection? This objection, accused number mentioned in cause title differs with remand application. Yes.
But the,
Accused number differs.
yes, my lord.
Hmm.
In the FIR, my lord, he's accused number 2, and in the remand, my lord, is accused number 3. And there's a
Third
defect with the respondent, my lord.
For the petitioner on office objections. Satisfied, the submission is accepted. Office objection in that regard is ignored. HGP takes notice for respondent. Private is recording. Yes, next.
Much obliged.
My lords, in items number 2 and 3, my lord, I've just been given instructions, my lord. But I understand that in item 2, my lord, the previous council has given a council submission on the office objections and that they've complied with the office objections, my lord. I will be filing my NOC wakalat over the course of the day, my lord. But I thought I'd bring this fact to the notice for
According to you, you complied as objections at serial number 1, 5 and 1, 4 and 5.
No, my lord, in serial number 2. In serial number 2 and serial number 7, my lord, these are connected matters. In that, office objections have been complied with. Serial number 3, 5 and 6, my lord, they've not been complied with. I just need 1 week's time to comply with that.
1 minute, tell me one by one. Now, what about serial number 2?
Serial number 2, my lord, my instructions are that office objections have been complied by the erstwhile council.
Yes, sir. You give your name, so and so submits that. Submits that, he will file wakalat on behalf of the petitioner during the course of the day before the office. He submits that all the office objections are already complied with. Office to verify and report. In the meantime, learned HCGP takes notice for respondent. Private idre happily. What about serial number 3?
3, 5 and 6, my lord, I need 1 week's time, my lord.
Counsel for the petitioner takes for time. 3, 5 and 6. To comply with the office objections. Yes. What about 7?
And 7, my lord, it's been complied, my lord.
7 complied at the office to verify. 7 only. In serial number 7, there are 2 more office objections.
My lord, I'll examine the file and comply with them, my lord. I just was instructed yesterday.
7 only. Counsel for the petitioner, place for time. Yes. 4.
Your lordship, with respect to,
So and so submits that he has filed wakalat for respondent number 2. Office to verify and show his name in the cause list. 4 none. Yes, 4. Counsel for the petitioner.
I am for the petitioner, your lordships, with respect to serial number 4.
Yes.
In the last date of hearing only, I had complained with the office objections, your lordships. I have in the para number 3, I have mentioned that I have not filed any other case in the Honorable High Court, your lordships. And further, before filing of this petition, your lordships, I had filed
No other case has been filed. Have you mentioned it? No
yes,
other
yes, your
cases?
lord. Yes, please, your lordships. Actually, before this petition, I had filed a criminal appeal as one of the offences was under Prevention of Atrocity Act. The office had raised an objection with respect to the maintainability. So I've already taken steps and filed for dismissal, your lordships. I'm producing the document, your lordships.
A document I do, no other case has been filed and whether you have mentioned in the petition.
I have mentioned, your lordships, that I had filed a criminal appeal and I've already taken steps to get it dismissed. And other than that, I have not filed any other suit, your lordship.
Counsel for the petitioner, counsel for the petitioner submits that he has already complied with the office objection at serial number 2. Satisfied. Satisfied by the office to verify and report. In the meantime, HCGP to take notice. What about 2? Serial number 2, 3, 4, 5, 6, 7, 9.
Lordship, it could be passed over. I will do the hearing after the.
No, HCGP has taken notice. He has to get instructions and
In the last date only, the HCGP had taken notice, your lordships.
without compliance of office objections. Agida. Are you ready?
I'll have it tomorrow.
Tomorrow ಬೇಡ ಮಾಡ್ಬಿಡಿ ಮತ್ತೆ ಇನ್ನೇನು. 4:39 ಇದೆ. Pass over.
Much obliged, your lordships.
First time matters ನಲ್ಲೆಲ್ಲ notice ತಗೊಂಡು. First time matters, HCGP take notice.
Serial number 9,
ರೆಸ್ಪಾಂಡ್ ಅಂದ್ರೆ ಅವರಿಗೆ
9 ಲೋಕಾಯುಕ್ತ ಫೈಲಿಂಗ್ ವಕಾಲ.
9 so and so filed wakala
Submission.
for the respondent
Serial number 11, my lord.
takes praise for time.
Serial number 11. Filing the 439 application, 306 application, 304, my lord.
CGP takes notice, sir.
Kindly fix the date
Yes,
next week.
date will be given. ಎಲ್ಲದರಲ್ಲೂ ಆಗಿದೆ. ಎಲ್ಲದರಲ್ಲೂ CGP takes notice. Special PP ಇದ್ರೆ ಅದು private respondent ಇದ್ರೆ ಅಲ್ಲಿಗೆ ಲಿಸ್ಟ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ. ಅದು ಪುಸ್ತಕಗಳು
ಡೇಟ್ ಕೊಡ್ತೀರಾ? 19.
ಲೈಬ್ರರಿ ಯಾವ್ದಕ್ಕೆ ತಗೊಳ್ತೇನೆ ಅಂತ ಹೇಳಿದ್ರೆ ಚೆಕ್ ಮಾಡ್ಬೋದು.
ಡೇಟ್
ತಗೋತೀನಿ ಅಂದ್ರಲ್ಲ ನೀವು ರೆಸ್ಪಾಂಡ್